matter. And this Hon'Ble court has already given the opportunity to the opposite party 2 times. But still opposite party appeal before this Hon'Ble court.
What do you want then? You see, you have become.
This is a
Sorry?
Actually listed for the purpose of the last order. One is
What is the urgency? Because every matter, I'm again telling you, all the matters will come up serially. At least hold on for 10-15 days, all the matter will be listed.
getting claim petitions related to Bahanga railway accident case. So the work, this honorable court, they were getting liberty to the petition to take an adjournment for the, because in the absence of the officer, it was the type of technical decision. But the trial court went ahead with the matter. So we challenge you to remove the injury. And we are not correctly taking adjournment. That matter is starting.
When that matter is coming? You should on 11th along with this.
my lord.
No, 11th.
I mentioned this matter before vacation, my lord. The date is fixed. It's a stay and state proceeding. Watching of province order. The date is posted for appearance, whereas the stay is operating of the honorable court. But the issue summons
Despite say the trial court takes some take up the proceeding, then I'll take care of that. Don't worry.
it is posted on 24th.
Let it be. Our officers knows the English.
But we have already
Orders are passed and then we stay. Then
summoned the issue to appear on 24th.
24th, if anything happens, you mention on that day. 24th, as it is, the cyclone is there, he will not take. Don't worry. 24th, you mention. If anything goes wrong, you must mention it. I'll take it.
Still doing a memo just in case.
Well, 24th, you mention. If anything goes wrong.
My lord.
Rather 25th.
My lord.
Okay.
Take care.
1 minute. Yes.
It's a fresh matter, my lord. CRLMC number 2457 of
This matter will come. Don't worry. All the matter, fresh matter will come within a week or so. Give me. No problem. All these matter will come soon. Don't worry.
What we have lots of fixed matter to 26/7/2024. Specifically, a date was fixed, but it did not come on that deadline for the informant. It's a question of a case.
Serial is everything.
My lord.
Yes, and mentioning there.
My lord, item number 39.
Yes.
Lordship's board, my lord. Lordship issued notice on the last occasion.
Yes.
It is a PWD Act case.
Hmm.
But noting is that SI is not back.
So the endorsement is address is moved. Hence written.
So I have to get the new address and that requisite may be accepted and I will give the new address.
Mr. Mishra, let me
Time may be given to collect the new address.
Submit that you file the fresh address and the requisite which has already been filed may be utilized for the purpose of serving the opposite party on the new address to be published by Mr. Mishra. Obviously, meet the matter. 40? Let me finish one. Getting. Yes, Mr. Tripathi.
My lord, there is a matter, a very urgent review petition. My lord, we filed a month back. Honorable Justice D. Das retired in the meantime, and the matter is very, very simple, small matter, hardly take 2 minutes. The execution court is
Review, Mr. Tripathi, review actually assigned to this bench specifically because it is the order has been passed by some other court. The honorable chief justice assigned. If at all it is assigned, I'll take it up.
It has been assigned. I mentioned yesterday before the Honorable Chief Justice. It has been assigned, and actually, this is review petition number 217 of 2024 only.
You tell me what is the urgency?
My lord, the execution court is conducting an auction tomorrow. Day after tomorrow, 24. So if it can be listed tomorrow, my lord. I've given my colleague is there in the memo. Is very urgent matter, my lord.
Okay. And what was the original order?
My lord, sorry.
Original order, this is a put the auction is being taken up.
My colleague is there. He's serving a memo. I only did it. Then I carried it to Supreme Court. The Honorable Supreme Court didn't interfere and asked me to file a review petition. Then I filed a review petition. I've taken that stand also because Supreme Court said that particular point has not been adjudicated so far. So that has to be agitated before the Supreme Court. Also kindly.
Dismiss what review I can entertain, I don't know. Okay, put it tomorrow, let us see. Very auspicious for getting a dismissal.
Physically, my lord.
Yes.
My lord, I prefer.
Let me finish that 2, 3 because they're not able to hear happening. So they're yes.
Item 57. Item 57, the Lordship had sent the matter for mediation. The date is fixed for 4th of November. It has been fixed.
Okay. Mediation process is still on. Release the matter 4th of November.
4th of November. Next date is 4th of November.
Okay, then we give after 4th November. Huh?
Interim orders, if any.
Yes. Give on 20th, huh? 20th November, interim order to continue. Okay. Yes.
My lord.
Any other mentioning online? No. Oh, yes. Yes.
Sir, I obtained the copy of the charge sheet in course of direct silence. After the counter in course of direct.
This is for what?
For passing of the cognizance. That's a electricity matter.
You want an adjournment then?
So day after, I enforce.
Not day after. Can you go to the later? I know. You file it, no problem. Finish the matter. 48. See, I'll tell you why I'm giving little late dates. Because there are many matters which have not even listed once. So therefore, that is the reason I'm giving. Mr. Japarullah, letter counsel for the petitioner submits that he will be filing the additional document during the course of the day. Release the matter on that in that week, 25th wala week. 25th wala week. To continue.
I beg your pardon, my lord.
Item 48.
Item 8 has become infructuous.
1 minute.
I beg your pardon, my lord.
There is a good news.
Item 8 has become infructuous, my lord.
Yes. Infructuous. 8. Yes. Okay. Yes.
38, my lord. Adjournment.
Old matter?
38.
Old matter. Interim order is there.
No, my lord. No interim.
Adjourn. 20, 38, adjourn.
38.
I on request. Oh, 38.
My lord, 38, my lord, I'm praying for adjournment. I will file the.
No, somebody filed a withdrawal.
I will file it. So, wife has to, is not interested to withdraw the child because there is some original amounts. It will be paid next week.
You are the petitioner.
I am the petitioner.
You have filed a withdrawal memo.
Withdrawal memo.
And then?
Two matters in view of the other past matter, it should be my lord, withdrawn. But she doesn't want to withdraw the matter because some error is there.
Not see, it is Amresh Patnaik.
Amresh Patnaik, two attached, another matter is attached. Another matters. I like wife.
Wife may not be interested, but the husband's petition can be withdrawn.
My lord,
You are the husband.
I am for the husband.
But you withdraw that. Wife may pursue.
Matrimonial case.
No, maybe. You have filed and withdrawn. Husband's petition is withdrawn and wife's petition is adjourned. Right. Wife's petition is adjourned. No. See, I tell you, why are you arguing for wife? I don't understand. Your petition, you have moved an animal for withdrawal. Let it be withdrawn. Wife will take care of her petition. Why are you worrying? And you are responding in that brief. Dispute. But then you argue, what is it? At least 50% is over. But don't I'll give a date and that petition is withdrawn and second matter you give a date.
Pardon to mention, my lord, item 3 lordship.
Yes.
Pro my lord, next to any debt lordship, personal defeat. Item 3 lordship. 3, my lord.
What is this matter? First matter.
My lord, post matter. My lord, earlier, my lord,
Next week it may not be possible.
other lordship.
CD? CD
Last one, Sibo corporate.
Yes.
My lord. Lordship of parents, my lord, adjournment person file, lordship earlier, my lord, the order passed, my lord. The adjournment person, trial court may be considered the
If that is the case, then you have to argue.
adjournment, my lord.
If you can't argue the matter there, and this is a convenience order.
No, my lord, is a charge lordship.
I can't hold the trial court proceeding.
Any date lordship,
I'm giving a date, otherwise you argue. I'm giving a date.
my lord.
I will not say anything.
My lord.
I can request.
My lord, I told any date lordship.
My lord, item number 12, my lord, I need an adjournment, my lord.
Sorry?
Item number 12.
Any interim order?
No interim order.
December.
Item number 52, my lord. It's a old matter. Why there is an adjournment, my lord? It's a case and counter case. Here, my lord, go.
52.
52. So staff of our registry and it's a family dispute. So the matter is compromise is going on. So they want 2 more weeks for settlement of the matter.
December.
Madam to mention, my lord, I am for the opposite party.
Which one?
I am mentioning for listing, my 130 DNA Act petitioner has taken stay. The reference is not listed, my lord. I am for the opposite.
Check the amount.
7.20 lakhs.
You are the complainant. Yes.
This is a matter of criminal division. In this case, actually, the petitions are granted bail only till 2nd of October. So, this matter requires agency. So, if it could be.
You have been granted bail.
Yes, sir.
Then what is the urgency?
So, it was granted, just to prefer the appeal under section 3 subsection 3.
What do you want?
So, the matter could be taken up.
This matter.
Yes, sir.
You have been convicted
Yes.
and bail has been granted. 389 benefit for limited time. We take it tomorrow. Take it tomorrow.
Blessed.
Yes. Press matter, take it tomorrow because yes.
Item 1.
Yes.
May I please, Lordships? Lordships, I'm appearing online on behalf of the petitioner.
Yes, madam.
This is a quashing matter. And Lordships, the FIR was registered in the year 2005. This is numbered as 14 of 2005 and it was by the vigilance. And
Yes.
the section under which the FIR has been registered, Lordships, are under sections 13(1)(d), 13(2), read with 12B, 120B and 420 IPC. And Lordships, in fact, the quashing is necessary in this case because it's a malicious prosecution. I'll show from the documents that right from the beginning that the FIR has been registered in 2005. The charge sheet gets filed only in 2012 and only in 2010 I am arrested. And prior to that, Lordships, I have been in fact a presenting officer in the disciplinary proceeding.
FIR is page 9.
Lordships, I'll take Lordships to the FIR. It's annexed to P1.
Yes.
Page 31. So, Lordships, the entire of the FIR does not contain my name.
No. You see, which is that matter? What is the name of the petitioner?
Lordships, this is. I am for the petition.
No, what is the name of your client?
Pradyut Kumar.
I think that's not
Pradyut Kumar Balbant
has been added. No. I'm see the you have a hard copy. Hard copy.
Message
Scan. That's
copies I have a version it is not legible also.
that apart. See in her matter, some other matter is scanned here. Some Pratimakar matter is scanned. Give the
In
hard
fact,
copy.
literally, the registry
Yes,
has
yes.
raised objection.
Yes, now I
Yes.
Yes, sir. Yes.
Lordships, the FIR is at page 30. Starts from page 29.
Yes.
And Lordships would see the entire of the FIR. My name does not get mentioned here. Last page,
Yes.
page 34, last para. If I may just read out the persons who have been roped in this case. Page 34. That's the inner page 4 of the FIR. Last paragraph.
Charge sheet has already been filed?
Charge sheet has been filed, Lordships. Charge sheet was filed after, Lordships, 7 years. And I was arrested only in 2010, after 5 years of the FIR being registered. And even in the charge sheet, there is just one para about me. The rest is about other officers. Lordships, may I first show, Lordships, page 34 in the FIR? My name does not get figured here. Page 34, Lordships, sir. I may just read out. It is therefore privately established that Shri Rajgopal Patnaik, the then DGM, law document, Shri Abhimanyu Patta, Deputy Manager Tech, Rabindra Panigrahi, the then JGM, and Shri Prabeen Kumar Nandi, the DGM of the Orissa State Financial Corporation, showed undue official favor to the promoter, Saeed Habibur Rahman, Managing Director of Jameel Lime and Chemical Private Limited, violating the norms of the corporation in the matter of sanction. As well as
now come to the charge sheet. What are the allegations against you?
Charge sheet, Lordships, is it's 37.
Yes.
And no, give it the charge.
In fact, the charge sheet nobody can read it.
Yes.
You got the legible copy? I don't have the legible copy. Apart from the all things said and done, he has not given the correct certificate regarding filing of 2 earlier cases. And have you ever filed any other petition?
I have filed another petition, Lordships. That's a disproportionate case, assets case. That is a different matter. That is, in fact, before the DB.
Pertaining to the same FIR?
No.
It's not pertaining. Same. Is not properly. The prosecutor says that pertaining to the same FIR, you have already filed 2 petitions which you have not disclosed. That would be a ground for dismissing this petition. That is given.
In fact, that is not to my knowledge.
CRLMC 2670/2010. He is telling you, so the CITRAJ, earlier case CITRAJ, first CRLMC 2672 of 2010.
Lordships, in fact, what probably he's not aware of it. These are the matters which are relating to the disproportionate assets case.
Madam, on the, if she has, your client has not disclosed these things to you, that itself is a ground for dismissal of this petition.
In fact, this order is.
See, there are 6. I'll tell you, there are 6 cases filed by your client. It's even and 2 cases out of them are filed by your client. One is a bail petition, another is CRLMC 2087 of 2023. That is here. That is the present case. And what else? 2672 of 2010. And 26, next one is 2672 of 2010. What was that? Writing. You kindly see the case 14 of 2004. Yes, same FIR, madam. 14 of 2000. Another revision is also there, 24 of 2011.
I make the
revision also. 24 of 2011.
In its correct position. Lordships, this 2672 of 2000. In fact, this is with regards to disproportionate assets with the other. In fact, it is surprising that this honorable court, the single bench, actually passed the order calling for the records of that case. That case has absolute no sync with this present case. In fact, if
arising out of the same FIR.
Lordship.
You will go into that. You tell me what is the merit in your
FIR. And
yes.
2023 in this case, it calls for the records of these 2 matters. In fact, it is surprising why the honorable judge has called for the records, because this does not relate to, this relates to a matter where in the disproportionate case, my client had some accounts and those accounts had been freezed by the CJM. And the single bench had in fact asked for de-sealing counts. So this is not relevant to the present case.
Yes.
And Lordship, case in the disproportionate assets case, that is, it is numbered as 34 of 2010.
Yes.
That was the case which was, this case was registered in 2005. That case has been registered in 2010. In fact, if the learned...
Yes. It was only replied for loss of analysis case 64. 64, yes. 64 I am there. But only brief. Loni has applied for the first term set so 60 lakhs during appraisal of first term to short term working capital loan of falsely mentioned the note sheet that the firm is a profit making company and if there is no default on account of term loan, promoters are genuine and reported to be creditworthy. Mr. H. L. Rahman, MD of the company, has successfully implemented the project and the unit has gone into commercial production within record time. The proposal short-term working capital loan shall be secured by existing industrial security and collateral security at a Guntur. That is outside the state. And recommended for sanction of the loan of rupees 60 lakh. What was he? He was the division, and he, on the basis of his recommendation, the loan was sanctioned, or ultimately loan the huge loss was caused to the government, the Oasis Corporation, and it was found then the collateral security was exchanged that is less than the value. Okay. All are connived. It's a case of all are connived conspiracy. 120. So it's a case of 2005 and now child in 2005. The proceeding is challenged in 2000. Hey, one of her ground is the delay. And another case was there. Other aspect is on the merit also. In charge sheet, his name is found place and very specific allegation against him, and it's a case of conspiracy. It's a branch of the state. Because of dependency, that the charge is to friend. What pendency? Is there any stay from this court? No, only a instance in which you work into more than whether present status of why are you doing well? The article was filed long way, 2012, and you have not even proceeded for framing of charge unless you show me that there is an order by any court. Staying the proceeding. That was the reason. Today morning I was asked him what is the present status of the case. You can't subject people to the harassment like this. 2005 FIR, 2012 charge sheet is filed. It is to be, you don't proceed against them. It is to be seen whether a delay is at one paragraph. So you write something, some name, and you ask no paragraph. Subsequent loan also being sanctioned. How will you explain whether you tell me? The instance of the prosecution or a prosecution is tell me whether delay is attributable to the second or not. If delay is not attributable, the delay itself is a ground for causing. Let it see. Let it to the second. If at the instance of any accused, or for that matter, this accused, if any stay order or anything is there, then one can understand. But if these accused have nothing to do, the article is filed 2012, today, see how many years? 1 decade. You take only for framing of charges. And even if you today frame the charge and proceed with the trial, what will you get? Ultimately, these people will be acquitted. 101% acquitted. You have the clear instruction. And this is, I don't know whether this is designed by the prosecution or benefit to the accused. Not for what reason, I don't know. Maybe. Then will you give me the status report? Immediate status report. Court also whether accused is responsible. The issue of scanning to proper. Yeah. What is this? You have scanned something. Right. Mr. Behuria, Lieutenant Constable, the petitioner, submits that the FIR was registered on 29/4/2005 235.
So it's
In the FIR, the name of the petitioner was not mentioned. And there was no allegation or overtake attributed to the petitioner. However, after investigation, charge sheet was filed on 31/3/2012. In the charge sheet, the petitioner has been implicated.
It's 2012. Immediately after charge sheet.
Give the date if you have.
Date is a
The trial court, although had taken cognizance way back in 2012, the trial has neither the charge has been framed nor the trial has proceeded in inch as yet. Therefore, on this ground, petitioner seeks indulgence of this court and seeking quashing of the entire criminal prosecution, apart from besides quashing of on merits as well. Mr. Maharana accepts notice and seeks to get instruction regarding the cause of delay. Leaves the matter after 4 weeks. In the meantime, a report which is that court.
special judge, vigilance, Kotak.
Special judge vigilance Kotak is directed to
Here, case number 2012.
the entire proceeding for the entire proceeding pertaining to FIR number is the matter after 2 weeks. After 2 weeks.
Yes.
Item 2.
One submission included in the order that in fact, there was a disciplinary proceeding against the other accused persons and I was the presenting officer. I was made a presenting officer. I have in fact gone.
Just I want to inquire about the delay part. Let me see that. Let me understand that, then we will include. Please it. Yes.
Item 2.
Yes. Customer name. Yes.
May it please your Lordship.
Yes, sir.
Here, my lord, I have challenged the order taking cognizance passed by the special judge vigilance in taking cognizance against the petitioners for the offence under section 13 of the Prevention of Corruption Act. 13(2), reduce section 13(1)(e). Petitioner before my lord are husband and wife, while the petitioner number 1 is working as a demonstrator. Petitioner number 2 is working as a lecturer, madam. The percentage of DA is 27%, and my husband and wife, they are dragged. One is a cancer patient, serious cancer patient. But if the case has been initiated, no allegation by anyone.
Who is the principal accused? Husband.
My lord, no allegation against anyone. They on their own initiated a case. Procedural, the reason was not because of the promotion, because of the wife of the petitioner number 1 is about to be promoted as principal. About the end of her career. The case has been registered. DA is 27%, my lord, may see. In the present era, my lord, 300%, 400%, 500% DAs are there.
But he has told in 10%.
15% usually. They take
10%. 10% is there in the case that has also been done.
27% DA and husband and wife, they have been dragged in since last 2013 till date. And when if the case is registered, that may continue against the husband. But with regards to wife, when nothing is there, she is a lecturer. And even if the entire DA will be calculated, they have submitted a sheet.
So what is the stage of the trial?
Cognizance has been taken, not been framed. 37% DA at the stage after completion of the investigation. Let it be against my husband. But picture number 2, her promotion has been delayed. Everything has been.
Show me what is there for. Let us concentrate on picture number 2. Let us see what are the allegations.
Only I am concentrated for picture number 2, which offering.
Let us see what are the allegations. What are the assets you have possessed?
Nothing. One is joint family, husband and wife. You know specific asset is that you are aware of. Well, let me see this. I have given the entire chart. They have, well, at page 44. 44.
Yes.
There is no pre-check asset period. They have said on their own in the asset. Well, let me see the at page 42. Well, brief facts of the case, it will be clear.
Yes.
After successful detection of trap case by vigilance, case number 65 of 2011 under section 13(2), that is one so. The house of accused Prakash Chandra Naik, demonstrator, Government College of Physical Education, Kulundi, Sambalpur, was searched and the matter was inquired into to open inquiry. On completion of inquiry, it was found that the accused Prakash Naik. So I am not pressing the obligation with regards to Prakash Naik. Was inquired into through open inquiry. On completion of inquiry, it was accused was in possession of used disproportionate asset in company to his known and legal source of income. Hence, the written report of EO PK Tripathi, Inspector of Vigilance, Sambalpur, this case was registered and investigated. The allegation in this case is that Prakash Naik demonstrated that his wife, Srimati Mandulata Naik, lecturer, both of Government College Physical Education, Kulundi, Sambalpur, the government servants acquired disproportionate assets to a tune of rupees 26 lakhs against total income of 53 lakhs 1,000 some odd, and total expenditure of 41 lakhs 47,000 during the period of their service 94 to 2011 in furtherance of their common intention, which they failed to account for satisfactorily. Investigation of the case revealed that actual Prakash Chandra Naik is the second son amongst 3 sons and 2 daughters of his parents. The late father of accused was a private Ayurvedic practitioner in the native place, so and so, and that so and so. The mother of the accused is housewife after no extra support. That is Manavir. The accused entered into the government service as a laboratory assistant in Government College of Physical Education, Kulundi, Sambalpur, Johnson, so where his post was upgraded in 1998.
Show me the assets now.
Malad?
I read it. Show me the assets.
Malad 44.
Balance it HBA.
44. Cost of one plot by Khata number so and so 1,33,000. One double-story building. Building constructed over plot number so and so 40 lakhs. Cost of one plot so and so Mouja Saraspur 7,150. Enter assets is this. And what about?
How will you get out of it?
Well, if person number 2 would have been a housewife, what would have been the charge? Section 12. Well, if Prakash Naik was found guilty, he was trapped, so let him be prosecuted. Why lady ballot?
Lady, she has independent income. She has public service.
And public service is true, nothing was, she was not trapped anywhere. As because my husband, I am a public servant, my husband is a corrupt officer. He is to be prosecuted. Why? I have been entangling in the case of the vigilance case. Let my learned friend show a single decision in that respect.
You are betterly placed than your husband. You are a lecturer.
I am a lecturer, not any
lecturer.
I mean, the problem got my salary. I have taken
joint acquisition. Problem is that
where is the enjoyment?
At this stage, I am afraid I can.
From my income, my lord, can I not purchase a land of 1,50,000?
So these things can be determined at the right stage. I can't at the cognizance stage. I can't distinguish.
If X has been determined,
the implication would be since the disproportionate is only 27%. If I'll cross this man and the disproportionate asset will come much below 10%. Then you are also out.
Then I will prepare a small chart out of it. If my income is this, my income was
then I will have to conduct a mini trial.
No mini trial, my lord. They cannot say anything, whatever that comes to their mind. What
is the interest you getting in the seashore securities? Seashore securities. What is that?
Seashore securities.
Interest you are getting, interest from seashore security. What is that? You have invested in seashore also.
Like, in the name of Prakash Chandra Naik.
No, you have done.
No, man.
Yes, I'll show you from the.
Prakash Naik, my lord.
I'll just show you.
My lord, that is A789. My lord, let's see.
No, I'll just.
But, my lord, let's see.
Come to page 43.
43.
Second paragraph. Read it. Accused persons are filing.
My lord, they have given specific. My lord, 44.
See,
Page 44.
whereas the wife Srimati Naik has knowing her income and salary, bank interest, and interest from the she source securities.
No, they have not shown it there.
That is rightly written. How will I distribute those things? How will I take it out from this? That's the difficulty. You may have a fantastic case, but in cognizant stage, what can I do? That's the difficulty. You file a separate application for discharge.
No, the stage of framing up charge, my lord, I have to do that.
Yes. You file a separate application for discharge and raise all these points.
Yes, my lord.
That's the best way of right up. The petitioner, I think for petitioner number 2 only you do it.
No, no, I'll do it for you.
Better, because petitioner number 1 you may not get right up. At the outset, अगर income tax submits that he is pressing the present petition insofar as petition number 1 is concerned. However, he is emphatically argued on merits regarding the involvement of petition number 2. He submitted that petitioner number 2 is working as a lecturer in a college and has an independent income. He has nothing to do with the acquisition of a disproportionate asset by his husband, and the onus of explaining the acquisition of the asset lies on his husband. And he sees the petition number 2 is innocent and falsely implicated in the present case. The petition number 2 is assailing the order dated 23/2/2018, passed by the Special Judge Vigilance Sambalpur in CTR number 5 of 2018, arising out of VGR number 32 of 2013, whereby cognizance of offences punishable under section so and so has been taken against him. I am afraid at the stage of taking up cognizance whether this court can go into all these things, all the defense, all the point raised by Mr. Dhar. Therefore, I am of the considered view that the petitioner should raise all the points before the final court at the stage of framing up charges. Accordingly, liberty is granted to the petitioner number 2 to move appropriate application in that regard. If such application is moved, the same shall be considered on its own merit. With this observation, the petition will be disposed of. Disposed of, yes.
Item 4.
Yes.
The petitioner challenging FIR on annexure 1 at page 19, your lordship.
Yes, sir.
On the ground that absolutely there is no offence made out against the present petitioners, my lord. If your lordship,
What is the stage of investigation?
I have to take instruction, my lord. Stage of investigation, my lord.
I'm simply urging to next week.
My lord.
You ask, I will not say anything. If investigation is going on, I will not interfere.
Absolutely, there is no.
I don't know. Investigation, something may come.
Your lordship may direct my learner senior to take.
That's what I'm saying. That's what I'm saying.
Schedule may be available for that.
Both the 4 and 5. Put it next week. Meanwhile, Mr. Ravana would get
Cannot be possible because your lordship may grant
2 weeks. And regarding the status of the investigation. Deprobative. If nothing is, they may file a closure report also, if nothing is there.
Closure report will not come because the main culprit is the police man behind this case. Police against a news level, reporter man case.
Offense, what is the offense?
Offense is 394 of 507. This is a very peculiar case, my lord. A reporter was arrested by the police. A news was published by one of the reporter. The present petition number 1 in each newspaper. In progressive party. There. In wrong report was published. Thereafter, the present petitioner, petition number 1, being the editor-in-chief of the one news channel in which the reporter was arrested, called a journalist of Procedural there. Asked him why
Actually, the police people and the journalists are in the loggerhead always. Both of them are. Anyway, let us see.
Yes, sir.
Thank you. Yes.
Item 6.
It is similar to yesterday's item number 78. It has been posted to 29th of this month.
29th. Yes.
Published.
29th. Give that number so that we.
Item 78 of yesterday's list.
78, huh? Pick it over. Yes. Yes.
Item 7.
Yes, sir.
In this matter, my lord, I could have asked to fix a date for giving chance to argument, but the fact remains I need instruction. What is the stage of this? What happened?
Trial.
No, it was posted for argument. In fact, I have been to that place personally for argue the case. I am not disclosing what transpired in the court itself because it is a omission thing. Thereafter, however, argument was heard in part. And I requested to pick another date for further argument. On that date, I could not attend, so the court closed the argument and asked the prosecution to argue the case. It's a very peculiar thing. Prosecution is to advance argument first and thereafter the defense will do. But I was asked to argue first. And part argument thereafter it was closed. So it is a case on section 376. It means argument. Otherwise, there is.
What have you filed here?
Well, I find that my argument has been closed. Direction was given to give me a chance to argue the case.
Then I'll direct.
No. What is the stage of the case?
You, once again.
Since order passed 2/3/2024.
24 case
Final order might have been passed. That's what you are saying. Now, if final order is not passed,
Exactly.
then it should be on. That
judgment was not passed. Suitable date is fixed to the argument. That will
the petitioner is agreed by the order dated 2/3/2024. Whereby the petitioner's prayer for accommodation and accommodation for a day and to argue the matter at length has been declined. Mr. Sori Indian Council admits that he has no idea whether the matter has already been concluded and judgment is pronounced or not. Be that as it may, in the event the judgment is not delivered by the court below, the court below is directed to rehear the petition at length and thereafter pass the judgment. With this direction, the petition is disposed.
If the judgment not
If the judgment is not pronounced, right, then he shall be reversed. Yes.
may I say one thing?
Yes.
I remain present 3 hours. And simply out of the 3 hours, I only argued half an hour. And I heard from the presiding.
Then what I'll say is, I'll give a direction to the trial court to fix a date and intimate to you. Otherwise, there would be, even though the judgment has not yet been pronounced, the trial court is directed to fix a date of hearing.
Your lordship may say.
Suitable date of hearing. Date of hearing and hear the petitioner obligations at length and thereafter pronounce the final judgment. And petitioner is directed to you have to go to the court for some when are you going to attend the court? Not that after taking this order you will
assisting
fix their local lawyers are there. If the date will be fixed
within a week, then within a week, fix a date within a week. Fix a date within a week and afford an opportunity. Yes, disposed of.
Item 9.
May I please, Your Lordship?
Yes,
It's a Belgium matter, but wrongly listed in the heading of place admission. Your Lordship, order.
where is that order?
Order is running page 8, Your Lordship.
Running back. Petition is accused on so and so case. On 20th, the petitioner absent, allowed application also for the case of record found that again the questions have been asked to have been questions also directed also these questions are directed to the question and the last chance. We can give up. If the questions are here, we have to appear in question tomorrow. Tomorrow.
21/3/2023.
22
Is order
the order was last in 23 to appear tomorrow. You was issued, you are coming after 1 year.
No, file is not someone.
Anyway, I don't.
Fix it. This is
And due to his repeated absence before the court below, the court below by the order dated 2018 issued NBW against the petitioner. The petitioner is agreed by the same. On instruction, counsel for the petitioner submits that the petitioner would appear before the court on or before 15th of September and resort to the remedy available to him under law.
He has not filed the order of NBW, madam. This is
and subject to the petitioner surrendering or appearing before the court on or before 15th of November and paying a cost of 1,000 because you are delayed. Cost of 1,000 to be paid to Tangi Bar Association. District Bar Association Tangi. The impugn order is kept in event. Don't correct.
Obviously.
Allowed.
item 10.
In my lords, your lordship may kindly see the order dated 29/4/2024.
Counsel for the petition submitted. So far as petitioner 1 is concerned, notice and the one year has been by the positions. He expects that so far as petitioner 1 is concerned,
Yes, my lords, matter relating to question of the criminal proceeding in terms of amicable settlement between the parties. My lords, in the meantime,
what notice was given to petitioner 1?
My lords,
Petitioner number 1, 41 notice was 41.
petitioner number 2. Petitioner 1 was released on bail.
One now.
My lords, the proceeding may be quashed.
Why?
There has been amicable settlement and only the money involved is 31,800.
Have you paid the entire money? Have you paid the entire money?
My lords. Payment is
Where are the 18 persons?
sir, they were present on 8/4/2024. So present ଥିଲେ. ଆଜ୍ଞା present ଥିଲେ ମୁଁ ଦେଇଛି ଆଜ୍ଞା ତାଙ୍କର
Why don't you call them once again?
ନା ସେଦିନ ସେମାନେ present ଥିଲେ ସେ ଦେଇଛନ୍ତି ପୁରା
It's all right. What is the wrong? Once again they will appear. What is the wrong? As per you, then I will go, then you can get this. They are accused, why are you giving leverage? Accused as per you. The complaint will also come.
Yes, ma'am.
Complainant, they are giving service to you, not to the court. Let them come, let them at least have the pain of coming to the court. In VC, that petition is always there. Next week. Okay, Monday. VC, let them appear and tomorrow, see what will happen is tomorrow they will blame you. My lords. I have never given instruction and all this thing will come now, fall in my lords. So don't give them the grace. Let them come appear. Monday.
Item 11.
Yes.
In this case, petitioner is a mother-in-law and father-in-law. Alleged offense, my lord, 493, 320. Notice. If you are in town, husband wife 13 felony.
I'll issue notice to opposite party number two.
I'm a 41 petitioner. Police them suddenly go by Baharku, bottle problem for a I say, Monsieur, son of I'm very much, but
What is the problem next 1 week after?
Tomorrow, but I have no course to action there. I would down the passport. You are already ground the case starts.
I can't do that. You file the process tomorrow. I'll take it up 1 week and we'll see to quash it. What is the problem? Yes.
Item 13.
Yes. Yes, sir.
13, my lord.
13.
13. One.
Selling order dated 6/11/2023. But before your lordship goes into my file, my lord, the issue involved in this.
How many petitioners? 9.
Yes, issue involved, my lord, very simple. Whether the court can take cognizance without there being a police report, or can the court apply its mind without there being a charge sheet or a preliminary charge sheet, whatever they call it. Your lordship may kindly come to the impugned order that is at page 19.
Yes, I'm there.
First 4 lines.
On perusal
of the case record, FIR statement, 161 CRP statement, up-to-date CDS, another document, it is found that prima facie material under sections.
That it might have been filed 161 statement.
Exactly. Your lordship has exactly, lord. This is 6/11/2023.
Yes.
Now, your lordship may kindly come to the page 21.
21, yes.
Column 3.
Yes.
Date of filing of charge sheet is 15/11/2023.
Yes, sir. 15/11/2023 charge sheet is filed. Okay. Cognizance is taken on 6/11/2023. How can it be possible?
I think there is
7-8 days before.
Perhaps there is a preliminary charge sheet sometime earlier.
How can it be?
No,
Preliminary charge sheet when the accused in custody.
Maybe typo. It may be 16.
16.
No. Order is 16. Order is
16.
Order is correct.
068.
It is just to appreciate. I don't want to snatch away an order.
Yes.
I just to appreciate your. So, an application was filed by IU for issuance of NBW under section 73. 2. The only thing court has to do is to see whether I am evading arrest and I am an accused. In that application, he has passed this order. Your lordship knows cognizance is not any act, my lord. Once court applies, it's not that is cognizance. Right. So this is what cognizance. Then you cannot take another cognizance because that will be second cognizance. So this is
I'm just I want to verify whether it is 16 or
that is 6. It is certified copy in your lordship's order. That is 6. Then order type देखिए charge sheet file हुई. If your lordship will go through the entire order, your lordship may kindly come to page 20.
No. He is correct, Mr. Ravada. Just see the top of the order. This case record is put up today on receipt of a prayer of IO, ASI, so and so, to issue immediately against the accused person under section 73(2) of CRPC. On that application, all these things has happened.
But the page 20, paragraph 2, the IO in person in the prayer, the case record made available material on record, it is alleged that the accused persons are also avoiding places. Correct.
No, last paragraph, page 20, you come to page 20, last paragraph. Hence, I direct IIC Jotni to arrest the accused person. They are committed offences under punishable under section so and so, and avoiding arrest of on.
How can we say this?
How can you say that? Without taking cognizance, you are saying that they have committed offence, they arrest them.
Take instruction from the IO.
Okay, issue notice, issue notice. I'm staying with that. This is not acceptable.
Your Lordship, can you stay operation of that order? So that
Yes. Operation. Issue notice.
You will also simultaneously also confirm the report from the court.
Report from, yes. Issue notice. Report from.
And source summary is the IO will appear on next day. It will be not.
so these are
Also, how can tell?
Let us consider for the petitioner. In this petition, petitioner had challenged the order dated 6/11/2022. Whereby the trial court, while dealing with an application under application of the IO for issuance of imbue against the accused persons under section 73(2) of CRPC has passed the following order.
I have to intervene. The IO made prayer on 6/11 order passed 6/11/23 manner. But the IO made prayer for issuance of individual in order to file some charge manner.
That's right. That's what I'm saying. In that application, can the court say this last line? Cognizance is not taken. Nothing has happened. And but last line, just see the page 20.
Hence, directed the IS justice to arrest the accused persons are committing offence such and such.
Arrest the accused person. They are committed the offence under section so and so.
how can
you give an opinion like that? In fact, it's not happily worded. I understand what you are trying to say. It's not happily worded.
On the when the IO manner unable to submit charge sheet manner, the accused persons are avoiding police arrest manner. For that,
I understand.
7 to manner.
What he's trying to say? What he's trying to say is this is tantamount to taking.
No. Cognizance, I beg some manner. Yes. Cognizance always taken against the offence. Not the court is when the police are unable to arrest the accused person, say pray for an issuance element.
Obviously, that
element is issued by
you are up to.
The offence not known
No, that is your answer. I'm not paying notice. You answer it. I understand that, but that's not happily worded. Right?
Petitioner challenge order to 6/11/23 whereby the High Court while dealing with the application of the IO for issuance of imbue against the accused person 72 CRPC party following order.
Following order. This last paragraph. This 20 last paragraph. In view of the material citizen.
This is what cognizance is.
Next paragraph. On 15/11/2023, charge sheet in the present case taken. When accounts for the petitioner submits that the impugn order is virtually taking cognizance of in the impugn order. By the impugn order, the trial court has virtually taken cognizance of the offence before the charge sheet is laid down. Charge sheet laid down. Issue notice written in so and so. Mr. Aroda seek time to file response to the petition. Leaves the matter. So in the meantime, the operation of the order dated 6/11/2023 is stayed till next date appearing based on leased on 19th of 19th of November.
And I some matter, page 34 matter, second paragraph. Second paragraph matter, in middle of the order,
Yes.
he mentioned after taking all sincere report by the previous IO, myself and accused persons would not be available. Nobody could say about the location. The identity of the unknown.
By the way, one minute. By the way, have you appeared before the IO? Why don't you appear? What are the offences?
It will better my
1 minute. Let us, question, I will answer it. Offences are not very similar.
They have come to me for filing of an anticipatory bail application. I will be honest before you ask. But I found it, I have suggested them to file a application under.
Absolutely right. What I'll do is, the best course would be for you also, consider it. I don't want to impose things. I'll set aside this order and give you liberty to appear before the court and I'll set aside this order.
Yes, it will be says instead of.
But in any case, tomorrow what I'll do? Eventually I'll
Exist.
But I can't give you bail. Obviously, you have to resort to the right remedy. I will set aside this order.
In fact, matter आपको समझ चार्ज
Your purpose is served. I set aside the order and giving liberty.
academical discussion matter. After submission charges, the police submitted charges showing them abscond. Then the court had to issue imbue, has to issue imbue. Since earlier directly submitted charges, that is
I said that it is not going to that issue. Technically, what examine what you are saying may be correct, but eventually what are you going to get? I will set aside this order. You achieve your object. Then resort to the remedy under law.
What is the argument regular? But
why unnecessary judgment? Unnecessary, I'll say something and it will give you. Right on. Continue.
But if this matter
I've heard Mrs. Also for the petitioner and Mr. Raghadas also. I'm of the considered view that the order dated 6/11/2023, whereby a NBW has been issued against the petitioner. Requires indulgence. Requires indulgence. Because the NBW has been issued against the petitioner on 6/11/2023 and subsequent thereto, charge sheet has been filed against them, showing them absconder. I have also perused the allegation made against the petitioner in the charge sheet. Regarding head to the nature of allegation and the tenure of the order dated 6/11/2023, I am of the considered view that the impugn order is liable to be set aside. Accordingly, the order dated 6/11/2023 passed by civil judge bracket JD cum JMFC Jatni in GR case number 3525 of 2018 is quashed, and the petitioners are given liberty to appear surrender before the court below on or before 20th of November.
I'll all the time.
Okay, 30th of November.
Instead of quash manner or in that order manner, you are still kept in abeyance. So that if then
I have then I will take notice law.
then the authority could scan the arrest number 6.
Recording is undertaking to appear. Undertaking on instruction, undertake to appear before the court below on or before 30th of November and resort to the remedy under law. In the event the petitioner shall not surrender as per the undertaking given to this court, it is open to the prosecution to move appropriate application before the court below.
Subject to your lordship, office is similar. Now the lordship has set it aside and has directed me to render before 30th. My lord, again the same situation will come. So liberty must be given to me to apply for anticipatory bail or whatever. My lord.
Liberty is always there. Refer to remedy under law 30. Within 30 years, you can move even tomorrow you move anticipatory. Who stops you?
My lord.
Eventually till 30th you got anticipatory. Till 30th nobody is going to arrest you. So in between
when there is no apprehension of arrest, I cannot also.
There is no apprehension with the 30th record. This is actually interim bill for you. Interim anticipatory bill for you. Whenever the magistrate going to pass individual in person, the pressure of what the language used by the magistrate that creates a doubt. So therefore he is correct, but you can't say that you have committed because you have applied your mind and taken cognizance. That's what there he is correct. You cannot apply your mind.
The magistrate instead of
he should have
he had to form opinion that there is.
We have to say that no, these are the allegations, that it is ready and they are not appealing, therefore we should not my learned friend is saying, kindly come to section 73. There must be one. This is only for academics. Youngsters are there to learn things.
And what happened? FIR which is
The court below, my lord.
After the restrictions of that, subsequently 161 might be come to the court balance even if somebody.
No. What he is trying to say is, at the time of issuance of NBW under 73(2), can be court form an opinion that wrong has been committed.
Then we have to find out when they allow that application, the 73 supposed to whether IO might set some of documents, FIR 161 statement, and the other CD might.
He says that I have paid 151 and all.
After allowing them to the application, the IO might
161. See the first second paragraph. Perusal of the case record, FIR statement under 161. Everything he has carried. Thereafter formed the opinion.
Not counted any error.
But whether it is tantamount to taking cognizance or not, that's the question.
Simple looking into the
Anyway, he's probably go then. Okay, thank you. Yes.
Item 40.
Yes. 14 pass over.
The 50.
Rejection of 205.
Lordship,
205
has been rejected, Lordship.
Now that judgment is there, you can move for fresh application.
Lordship, meanwhile, he has been released on bail, Lordship, subsequently. But he is suffering from spondylitis. And
Spondylitis, I am also suffering.
And different elements for which he is unable to appear.
Spondylitis is not a big
it is there. And also working in Sambalpur, Lordship, for which he is not.
But you have after the judgment of the Supreme Court, have you applied?
No, Lordship.
Prior
to that.
Yes, PMLA matter.
That personal judgment he can go surrender and.
He already surrendered and released on bail.
You released on bail and now guideline is fixed.
I think in PMLA case he has not released on bail. What is the question of
205?
But he
moved an application for 205, is rejected.
Yes, Lord.
And on the ground, now the guideline has already been fixed. On that basis, have you applied or not? Where is that? Show me.
That we have applied for the certified copy, Lordship.
That Lordship will call it tomorrow. I have to verify on that ground because your Lordship will call it tomorrow. What I have gone through this application, Lord,
this 205 was filed prior to personal judgment.
That's what I'm saying. Now,
May adjourn it for 2 weeks after.
why 2 weeks? Tomorrow, Mr. Agarwal will tell.
I just verified.
No certificate copy is required. If you have moved the application prior to that, then give liberty, fresh new application according to that, the court will decide.
Yes, sir, that's.
Shall we withdraw it now?
Lordship,
Tomorrow.
Lordship, tomorrow.
Yes, tomorrow.
Tomorrow, day after tomorrow.
Day after, okay.
Day after.
Yes.
16.
Anybody? Pass over.
17.
Right, teacher aspect. Your Honor, the petitioner has challenged the order passed by the London Special Judge Vigilance, the Assistant Solicitor Ballot, rejecting my application filed under section 239, my lord.
Yes.
It's a very peculiar case. My lord and friend would also admit with me. My lord, we see Arresture 1, the first information report.
Yes.
Wherein my lord will see the chief engineer, superintendent engineer, assistant engineer, junior engineers are accused, along with last accused number 8, Judicial of Orissa.
You are Mr.
I'm Sanjeev Parikh.
Orissa.
But after investigation of the case, the vigilance authorities, they found that none of these public servants are accused. But allegation against them that they have allotted a tender to Judicial of Orissa, who is a special cast contractor, by deviating the norms, and thereby loss of some.
Who are you?
I'm son of Judicial of Orissa. Judicial of Orissa.
Judicial of Orissa is the contractor. Who got the contract?
My lord.
And these people, the officers have given the contract to your father.
My lord will see.
How?
My lord will see page 21.
21.
Well, I received the case and registered the case under section 13(2), ready section 13(1)(b).
All the public servants have gone.
Yes. And 120B. 120B was against Judicial of Orissa. They submitted a charge sheet for the offences under sections 467, 466, 467, 468, 471, and 420 of the Indian Penal Code.
No, 120B is not there.
Yeah, 120B is not, nothing is there, madam. Even when the case, on the basis of the application of the public prosecutor, court was pleased to take cognizance against Judicial of Orissa, and that has also been quashed by this honorable court. And madam, peculiarity,
The father's case has been quashed.
madam, peculiarity of the case is, my lord and friend may submit that initially an application was filed challenging the cognizance, but due to the sad demise of the law and counsel who was appearing in that case, it was not pressed. It was non-prosecuted.
There are two more applications under 239, which is
They are also
the
at the stage of charge.
Right.
And my application has been rejected. My lord, may kindly see the rejection order.
Yes. 36.
Case 36. It has been alleged in the affair that a suspect officers, namely,
Instruction agent.
Because this is, see, father's case gone. Father officer gone. 120B is not there.
Found from the record, available from record, father has no role. So,
Father is the contract, yes.
yes, nah, father has not, he was the man.
Okay, 22nd. Madam, 22nd? Sorry, no. 22nd. 11. Issue notice. Mr. Moran accepts notice and seeks time to get instruction in the present matter. Lease the matter.
well, if an application will be filed.
In the meantime, if the trial proceed.
How big is
In adjournment, owing to the fact that the matter is sub judice before this court. Yeah, this is, I think it is happening. Let us. Otherwise, you generally, the very fact that you say that I'll seek instruction means there is something. I'll just know. Counsel for the item number, and counsel for the petitioner seeks to withdraw this present petition, being infractious, in view of the development, in view of the order 5/8/2024 passed by learned court below. Learned court below. Petition goes up. Thank you very much.
Indicate my appearance.
Definitely, rather writer, Mr. Agarwal pointed out that by the order dated so the trial court has allowed in view of personal judgment reported in criminal appeal number 2 allowed the petitioner to be released on PR bond and already released on PR bond by relying the judgment of Tarsim Singh, personal director of enforcement in criminal appeal number 2608 of 2024. In view of criminal appeal number 2608. Yes, 2608. 2608 okay. 2608 of 2024. There is an order of the court. Okay, thank you.
18.
May please, madam. I am permitted to proceed on procedural mode, my lord. It's a case, my lord, where the present petitioner is related to the principal accused, my lord, one Gunanidhi Durga, my lord. I'll have a glance to my lord, turn to page 12, and next to my lord 1, my lord. That is the affair.
Where is charge sheet, sir?
My lord, cognizance has been taken by mercy. It is on page 15 onwards, my lord.
Where is the charge sheet?
I'm sorry that I have not placed the charge sheet. Only I may be permitted to place 1 minute, my lord.
Yes,
affair starts from page 12. All allegations have been made against the one Gunanidhi Durga, the alleged principal accused, that he is the person who has contacted the informant, who is a married lady of 27 years and having also some child. Thereafter, her marriage was broken with her previous husband, and then she left with that Gunanidhi Durga, and they remained in Bhubaneswar for some time. And my role starts in the last page, one line from page 12, my lord. May I please, sir? एहापरे 28/1/2021 तारिख दिन अभियुक्तर आत्मीय स्वजन यथा कपिल दुर्गा, गजानन बिहार प्रेजेंट पिटिशन माइलर बिफोर माइलर वैकुंठ दुर्गा सचन अन्य किसी व्यक्ति मिलित भाव आम रोहुतबा भवानीपाटना बड़ा घरे रात्र पर सचन पहुंचले जबरदस्ती नाना प्रकार स्लैंग लैंग्वेज बाड़ेइले दे असल्टेड या निखोज विषय मो बापा कलमपुर जानिथिली देन देयर आफ्टर माइलर इट इज alleged that the said principal accused has married to another lady. So admittedly, I don't have a role regarding kidnapping. I don't have a role regarding marriage or keeping physical relationship. Now, my lord, in the meantime, the principal accused, my lord, has given a order. I have given a copy of order, my lord, CLMC number 3269/2022. I have, my lord, supplied today, my lord. I have not filed it. I have supplied today, my lord. I'll have a glance to it, my lord. CLMC number 3269. My associate has supplied, my lord. 3269/2022, my lord.
But your associate is also not there.
But here, given a copy to.
He's trying to
provided.
Where is that?
Madam, CRMC number 3269/2022, madam.
Yes.
Madam, the principal accused, my lord, against whom I have read the allegation, because of the fact this is not a case of sexual assault that has been ruled by the Honorable Court, and para 6 and 7 are of the order, my lord, is relevant, my lord.
Now, what do you want? Same order.
Madam.
Same order.
Madam.
Have you seen it?
Yes.
Same order will pass. Okay. Same order. Move it to be high part. Same order. Okay. Same order. You will surrender. 1 minute. You surrender on or before?
My lord, say 3 weeks, my lord, any day. Pardon?
You will be surrendering on or before 20th November?
My lord, my lord. By, my lord, say by. So I can able it by to do day after tomorrow also.
ठीक है, dispose of, yes.
Oblige.
Made this man. Well, matter of commissioner is the assistant fishery officer.
19, huh?
Assistant fishery officer, my lord. And now, my lord, under section 7 of Prevention of PC Act, my lord, it has been alleged that a check, he was caught red-handed with a check, my lord. And the FIR says that there is an SCG group, self-help group, who is to take subsidy from this feeder of regarding that fish feeds and other things, my lord.
Yes.
And to get that subsidy, they have to route this payment to the feeder through this assistant to the fishery department, my lord. My lord, what has happened? The allegation is that there is the SCG group and the son of the president, my lord, has filed this FIR, saying that the assistant fishery officer demanded the bribe and we gave them through a check. And when this check she was taking that check, she was caught over there, my lord. And the trap proceeding says that she was caught over there. My lord, two things that arises out of here. First, that whether a person who is not a part of a self-help group, this self-help group, my lord, is totally a women's group, my lord. Here there is no question of any male member coming into the picture. Here the son of a president of the group, my lord, has filed this case. First point. Second, my lord, whether under section 7 of PC Act, whether the check can be an element of bribe. Because he is not encashed it, neither there is an element of any demand or acceptance.
The first question, the answer is if a cognizance offense is made out, anybody can be a complainant. Answer is that.
First,
second question answer is Silla call.
My lord, question over here is that she has not encashed.
In Silla call case also the same thing happened.
My Silla call case, my lord, what has happened, my lord, here
there also check was given and we got dishonored. And on that,
here there is question of
was initiated.
No, my lord. Here there is no question of any dishonor of that check, my lord. Here the question
you are not presented.
No, I have not presented. That checks normally comes to the department to be produced before the feeder, my lord. That
no case is given to you.
No case is
the check is in the name of
in the name
personally.
Blank check, my lord. Blank check, not in the personal name also. Normally, because why it is blank check? Because the feeders are different, my lord. We have to put the name and we have to give them. So they get a subsidy out of it. For example, if the feeder is yielding around 2 lakhs, they get a subsidy of 1 lakh, something like that. So this is for this reason.
Let us come to the allegation.
Yes, my lord.
38, okay. Yes. Read it out.
That is the problem.
ଦେଖି ଜାଣିବାର କାରଣ ଏଇକି ଯେ ଶ୍ରୀଯୁକ୍ତ ନିଗମାନନ୍ଦ ସାହୁ ନିଗମାନନ୍ଦ ସାହୁ ସ୍ୱାଂଶ ସମଲା ଏସଏସଜି ଫୋରମରେ କିଛି ଦିନ ହେଲା ମାଛ ଚାଷ ନିମନ୍ତେ ବଳରାମପୁର ଗ୍ରାମ ପଞ୍ଚାୟତରୁ ପଞ୍ଚାୟତ ସମିତି ପୋଖରୀ ଲିଜରେ ନେଇଥିଲେ ଏବଂ ମୋ ମା ବୋଇତ ସାହୁ ସେଇ ଗ୍ରୁପରେ ମେମ୍ବର ଅଛନ୍ତି ଏବଂ ସଭାପତି ନଳିନ ସାହୁ ସମ୍ପାଦିକା କଳ୍ପନା ପ୍ରଧାନ ସମସ୍ତ ମେମ୍ବର ମିଶି ନିଷ୍ପତ୍ତି ନେଲେ ଯେ ପଞ୍ଚାୟତରୁ ନେଇଥିବା ବନ୍ଧଟି ବୁଝାବୁଝି ପାଇଁ ମତେ ଦାୟିତ୍ୱ ଦିଆଗଲା। ଆମେ ଜାଣିବାକୁ ପାଇଲୁ ଯେ ଫିସରୀ ଡିପାର୍ଟମେଣ୍ଟ ପଞ୍ଚାୟତ ପୋଖରୀ ନେଇଥିବା WSHSG ମାନଙ୍କୁ ସରକାରୀ ସହାୟତା ମିଳୁଛି। ତାପରେ ସଭାପତି ଓ ସମ୍ପାଦକ ମତେ କହିଲେ କି ଯେ ବ୍ଲକକୁ ଯାଇ ଫିସରୀ ଅଫିସର କିଏ ଅଛନ୍ତି ତାଙ୍କୁ ବୁଝିକି ଆସିବୁ, କଣ କଲେ ଆମେ ସୁବିଧାରେ ମାଛ ଚାଷ ପାଇଁ ସରକାରୀ ସହାୟତା ସୁବିଧାରେ ମିଳିପାରିବ। ତାପରେ ନାକ୍ଟି ଦେଉଳ ଏଫ୍ଓ ମ୍ୟାଡମକୁ ଭେଟ କରି ତାଙ୍କୁ ପଚାରି ବୁଝିଲୁ। ସେ କହିଲେ କି ଆପଣ ମାନେ ସରକାରୀ ଫାର୍ମ 50% ଓ ବାହାରୁ 50% ମାଛ ଜାଳ ଆଣିବେ, ମେଡିସିନ ଚୂନ GST ଥିବା ବିଲ୍ ମଧ୍ୟ ଆଣିବେ ଓ ଦାନା ବାବଦକୁ କହିଲେ କି ପଶୁପତି ଉଚ୍ଚ କାର୍ଗିଲ ଆଦି ସେମିତି କେତୋଟି ନା କହିଲେ ଏଇ କମ୍ପାନୀର GST ବିଲ୍ ଥିଲେ ଆପଣ ମାନଙ୍କୁ ଯେଉଁଠି ଆଣିଲେ ବି ବିଲ୍ ଅସୁବିଧା ହେବ ନାହିଁ। ଆସିଥିବା ବିଲ୍ ଗୁଡିକ ଆଣି ଆମ୍ଭ ମାନଙ୍କୁ ଦେଲେ ଆପଣଙ୍କର ସବସିଡି ପାଇଁ କିଛି ଅସୁବିଧା ହେବ ନାହିଁ ଓ ସୁବିଧାରେ ସବସିଡି ପାଇଁ ପାଇପାରିବେ। ମ୍ୟାଡମଙ୍କ କଥା ଅନୁସାରେ ଆମେ ସରକାରୀ ଫାର୍ମରୁ 50% ଆଣିଲୁ, ଔଷଧ ଚୂନ ଦାନା ମଧ୍ୟ ଆଣିଲୁ।
ତାହାର ସମସ୍ତ ବିଲ୍ ଭାଉଚର ମ୍ୟାଡମ ଛୁଟିରେ ଥିବାରୁ ଫୋନ ଯୋଗେ ଯୋଗାଯୋଗ କରି ଜଣାଇଲୁ। ସେ କହିଲେ କି ଏଗୁଡିକ ଚଳିବ ନାହିଁ, ତୁମକୁ ମୁଁ ଯେଉଁଠି କହୁଛି ସେଇଠି ଯାଅ, ବିଲ୍ ଭାଉଚର ଆଣିବ, ନହେଲେ ତୁମର ବିଲ୍ ହେବ ନାହିଁ। ମ୍ୟାଡମଙ୍କ କଥା ଶୁଣି ନିରାଶ ହୋଇଗଲୁ। ତାଙ୍କୁ ଅଫିସରେ ଦେଖା କରି ସମସ୍ତ କାଗଜପତ୍ର ଦେଖାଇବାରୁ ସେ କହିଲେ ଏସବୁ ଚଳିବ ନାହିଁ, ତୁମକୁ ୟୁନିଫାଇ ସମ୍ବଲପୁର ଭାଉଚର ଆଣି ଦେବାକୁ ପଡିବ। ଆମେ ଆଣିଥିବା ପ୍ରଧାନ ଫର୍ମର ଜିଏସଟି ଅଛି କହିଲେ ମଧ୍ୟ ମ୍ୟାଡମ ମହାନ୍ତି ମୋ କଥା ଶୁଣିଲେ ନାହିଁ ଏବଂ କାଗଜପତ୍ର ଫେରାଇ ଦେଲେ। ତାପରେ ମ୍ୟାଡମ ଫୋନ ଯୋଗେ ଯୋଗାଯୋଗ କରିବୁ ସେ କହିଲେ କି ଆପଣ 20,000 ଟଙ୍କା ଲାଞ୍ଚ ଦେଲେ ମୁଁ ବିଲଟା ପାସ୍ କରିଦେବି, ନହେଲେ ଆପଣଙ୍କର ବିଲ୍ ହେବ ନାହିଁ। ହେଲେ ମ୍ୟାଡମକୁ କହିଲି ଯେ ଆମେ ବହୁତ ଖର୍ଚ୍ଚାନ୍ତ ହେଇଗଲୁଣି, ଆମ ପାଖରେ ଏତେ ଗୁଡେ ଟଙ୍କା ନାହିଁ, କଣ କରିବୁ? ହେଲେ ମ୍ୟାଡମ କହିଲେ କି ଆପଣ ସେଇ ସମଲାଇ ଗ୍ରୁପର 20,000 ଟଙ୍କାର ଚେକ୍ କାଟି ଦିଅନ୍ତୁ, ସେଥିରେ କାହାକୁ ପେମେଣ୍ଟ ହେବ ତାହାର ନାମ ଲେଖିବେ ନାହିଁ। ପ୍ରେସିଡେଣ୍ଟ ଓ ସେକ୍ରେଟାରୀ ଦସ୍ତଖତ କରି 20,000 ଟଙ୍କାର ଚେକ୍ ଆଣି ଦେଲେ ତୁମର ବିଲ୍ ପାସ୍ ହେବ। ହେଲେ ଆମେ କହିଲୁ କି ମ୍ୟାଡମ କମ ଟିକେ କରାନ୍ତୁ, ଆମେ ଗରିବ ଲୋକ ଖର୍ଚ୍ଚାନ୍ତ ହୋଇଗଲୁଣି, 18,000 କରାନ୍ତୁ। ହେଲେ ସେ ରାଗି ଯାଇ କହିଲେ କି 20,000 ଚେକ୍ ହେଲେ କିଛି ହେବ ନାହିଁ କହି ଫୋନ କାଟିଦେଲେ। ଏଇ ମତ୍ସ୍ୟ ବିଭାଗର କର୍ମଚାରୀ ଏମିତି ନିଷ୍ଠୁର ହେଲେ ଆମ ତାପରେ allegation was lodged. And the thing that section 7 is concerned, only demand matters next of offense.
It has to be accepted. Cannot say that.
And it is the acceptance who has filed this and the check was anybody can lodge complaint in the state court.
Lodge complaint. My lord, one thing, first and foremost, my lord, who is he? Who is he? He is nobody over in this picture, my lord. He is a person, my lord, who
He has got the contract.
No, not him.
So that's what he's saying.
No, he is totally a stranger to the transaction. My lord, somebody, his mother is working in that SG group or the president or secretary. My lord, he is nowhere connected. So if somebody is not connected to an official capacity, my lord, he is nowhere connected with having any nexus with the department, my lord. Can he go and place all these things that ame golu dekha kolu se manna kale and everything? My lord, my submission is that first his legal status as a complainant has to be examined, my lord. That whether a person who doesn't have any official nexus with the fishery department, neither he is a member of the ASG, he is claiming that I am relative of somebody who is working in that ASG. So the president and secretary directed him. Is there any my lord, has he placed any iota of evidence that where the direction was issued to him that he will communicate on their behalf, my lord? Nowhere it has been stated like that. Now, secondly, my lord, check, my lord, it was presented to her and it was never presented before any bank. If at all that check was in the trap proceeding, it was, my lord, it was never presented before any bank. And it was a blank check, my lord. And secondly, why these checks are given, my lord? For the feeder to come in, because these feeders, my lord, there is a working program where this feeder has to take the check and they have to give the subsidy, bills are passed and everything has to be done. So they didn't brought all those papers intact. So that was definitely, she told them that you go back and bring the correct papers before me.
Yes.
Now, my lord,
Do you have any judgment regarding complaint? Your application was turned down.
My lord, my application for document was turned.
This is under investigation.
Okay, it's taken on investigation stage.
And the plea is that he asked for some documents. But once he asked for that, last check,
Here, my lord, sorry.
But your first submission is against the first principle.
My lord,
The first submission is against the first principle. Cognizable offense, anybody can be complained.
my lord, my submission.
And particularly when you say
offense
that the mother and the other office bearers have authorized him to go and tell.
No, there is not allegation.
No, not written, but the complaint is says.
The complaint is anybody can come and present a check, my lord. Somebody, for example, if somebody.
And demand is not, demand is, check is demanded.
Blank check is coming. See, my lord, two things. First, my lord, who is he? He is a nobody. My lord,
Anyway, what
26.
26. Yes.
My lord, it is equally well settled that mere recovery by itself cannot prove the charge of a prosecution.
Not recovered. Where is the question of
This is with regard to, my lord, what I am submitting is regard.
Investigation is still going on. How can I, whether it is recovered, is not recovered, what happened?
My lord, only the part of FIR, only the part of FIR, my lord, if such FIR is sustainable in the eye of law.
No, that, I don't think, only Vayu can do that. I will not do that.
Appreciate one thing. Two things are very much important, my lord. Kindly appreciate.
No, in the local thing you say, very big agreement.
My lord, locus thing, I will come, then I will come back with the judgment.
When you come back, I am not satisfied.
My lord, I will come back.
Simply 2 years. You satisfy me?
On the locus.
And this complaint, the locus of this complaint. You satisfied? Otherwise, investigation is going on, I will not satisfy. Simply like that, huh? Yes.
Yes. 20. May.
May I please, madam? Here is a case, madam,
Yes.
where I have approached the Honorable Court, assailing the action of the concerned authorities not to release my vehicle, although that has been allowed by the landed court to be released in my favor. I am on to page
This is item
9, my
20.
lord. Page 9, my lord. Page 9, my lord.
Yes, 9. Okay.
Page 9 is the order. Page 10 is the operative part of the order, wherein the vehicle has been released in my favor. And by the order dated the page 10 last order 27/6/2024, and pursuant to my lord's direction, I have complied with the direction of the Honorable Court, Landed Trial Court, and accordingly, my lord, the vehicle has been released in my favor. Then my pray, my lord, to have a glance to page 12. That is the order of the landed magistrate, JMFC M. Rampur, thereby directing the forest range officer Norla District Kalandi to release the vehicle as because of the fact that it has been directed to release by the landed court, and I have complied the order of regarding my security all such aspect, my lord. Now, in spite of all such things, my lord, now he has not released the particular vehicle in my favor, for which I have constrained to approach the Honorable Court. But one development has been occurred in the meantime. Yesterday, he has released the vehicle in my favor, my lord. So that grievance I don't have because right now, because it has been released in my favor. Only two things I have to approach this Honorable Court, my lord, with the liberty I pray, my lord, to dispose of the application, that I may be allowed to file appropriate application for compensation, including violation of the order of the Honorable Court before the appropriate forum. That's all, my lord.
That liberty is there. Why should I give you a handle for that?
Why I am saying so? If my lord,
Your grievance is taken care of, and whatever is permissible under law, you do it. Why should the court I am not an advisory jurisdiction.
No, my
I am here to see whether legality of an order that has been complied, it has become infractious, whatever is available to you under law, you do it.
Well, complied means complied after 4 months, my lord. In the meantime, I have suffered.
So the consequence will follow.
My lord. So that's why my humble submission, unless or until my lord to dispose of the application with his liberty to me to approach the concerned forum, the court below will say because of the fact it has been closed by the Honorable Court, so no such things. Only
liberty will be problematic thereafter. On that basis, you will start some prosecution or something.
Obviously, because of the fact that, my lord, they have not, it has been passed by order. The authorities are bound to accept the order.
Okay, I'll say like this, that the petitioner is agreed by non-compliance of order dated 26/6/2024, whereby a direction has been made for release of the vehicle with certain condition. Mr. Chand, counsel for the petitioner, submits that despite the fact that all the conditions have been complied with, the vehicle has not been released. Therefore, he approached this court. Instruction. He submits that yesterday the impugn order, terms of impugn order has been complied with, although belatedly. Therefore, he submits that the present petition has become infractious and infractious. At the same time, he submits that liberty should be granted to take appropriate action against
compensation.
Against whom?
My lord, the forester range officer, Norla District Kalandi, my lord. Page 12, my lord.
Against the erring official for compensation and appropriate and to draw up appropriate proceeding. If law permits, he may do so.
Oblige.
21.
Password.
22 page for well, the order dated 18/9/2020 the law and age in VR case where additional charges 420 is framed at the stage of argument, my lord. The lordship at peruse the order, my lord, at page 39. The Lord Magistrate also recorded no new materials has been amassed to warrant a new trial in this case. And thereafter, my lord, 420 and 34 has been added in this case, my lord. Initially,
Where is the impugned order?
Impugned order is based at page 39, my lord, lordship, 38 and 39.
Yes, read it. 38, yes.
All the offences are tried by magistrate. GR case has been transferred for disposal for the London ASF. Initially, the offence 409, 419 and 468 to 34 IPC has been registered. And after completion of the trial, the case was posted for argument. And at that time, my lord, the London court below from the charges. What was the original charge? Original charge is 409, 419, 468, 34. And the allegation, my lord, the present petitioner is the chief representative of the Unit Trust of India having a office and Gayatri Investment Consultancy situated at Paripada.
Charge is altered only. What is it?
My lord, I have stated, my lord, your lordship, there is some restriction is there. Even, my lord, in 217, also the recall of witnesses when charge is altered. I have stated in page 6, your lordship, have a glance.
Page 6.
6, my lord, paragraph 6.
Of your petition?
My lord.
Yeah.
My lord, that it is humbly submitted in view of the section 216. That the court may alter the charge but subject to some restriction in view of the ratio laid down in the Anta Prasad Sinha case, my lord. Whether without evidence being adduced, another charge would be added. Court can change or alter the charge if there is defect or something left out. It is not be understood that unless the evidence has been left, the charges already framed cannot be altered. For that, it is not the purport of the section. In view of section 217, recall of witnesses when charge altered. Whenever a charge is altered or added to by the court, alter the commencement of the trial, the prosecutor and the accused shall be allowed to recall or re-summon and examine the witness reference to such alteration or addition. Any witness who may have been examined unless the court for reason to be recorded in writing considers that prosecutor or the accused as the case may be desired to recall or re-examine such witness for the purpose or vexation or delay or for defeating the end of justice.
What is your case?
My lord, my case, my lord, then the complainant, my lord, purchased some share, my lord.
Yes.
Receiving the entire cash on behalf of the Vishwaman Das, present petitioner, but they have not yet been transferred the share to my demand account and they have also cheated.
409 is already.
Yes. 409, 419, 468, 34. The order is itself the learning.
What is prejudice? It is a lesser offense.
Yes. No new materials has been come.
It is a lesser offense.
Life impeachment is there. 714.
409 like.
Therefore, it is a lesser offense. That is been High Court of examined.
If you are completing on 409, if 420 is nothing. Had it been otherwise, I would have been interfered. You are correct, absolutely correct. Because the court says that there is no material law. See, the offense is a law offense. So, such and such will be there. After that only, if the day Takes me care. Why the provision? Leave it here, sir. Leave it here. You have done your job. What should I do? What should I do, sir? You will withdraw it to proceed. To raise all the point and expansions. Then counsel for the petitioner seeks to withdraw the present petition to raise all the to urge all the points before the court viewer at the appropriate stage. With this liberty, the petition is disposed of. Yes. 23. Yes, sir. Yes.
Charge sheet is filed under section 7 of the PC Act.
Yes.
The PC Act. And it's
an application for discharge.
No, just a minute. I have filed a, before charge is framed, I file a petition under section 239, leading to 27 to discharge me. No discharge me. The magistrate, the learned judge is thinking that once it is a charge under PC Act, probably these sections, two sections are redundant. Means to say, like you must see, page 45. Order 45 of the order.
Yes, and there.
Admittedly, written report of complaint was presented before SP Vigilance Cutter Division Cutter, and on 8/11/21, the facts which compel the complainant to make or making advances before the vigilance authority are also carried utmost importance. It is further found that it is presumed to say, it is presumed. Yes, sir. It is
premature to say.
It is premature to say anything of this state in respect of the integrity of the statements made by the witness. It can be considered only at the time. The role of present accused in the alleged offense, as well as in this plea mentioned in the discharge petition, can well be adjudicated during the trial. Lawyers will settle that the court at the stage of framing charge has to apply its mind to that question whether or not there is any ground for presuming a commission of an offense by the this is presuming. He has said that presuming. But this then said rejected the petition.
Don't go by a simple one word somewhere in the the fact remains there are material on the basis of which the charge has been placed.
It is not that. Presuming must be accompanied by the document.
Many times the words are not happily used, doesn't mean that the entire order goes.
That's right, sir. But once you presume something, it must be not arbitrary. Like chori corruption is punishment by law. This is not presumption. Presumption must be.
What we mean to say is prima facie he found out. That's what we mean to say. Chosen of anything around word.
It's not a wrong word. My lord, your lordship see in a trap case. Usually,
and see, these are the cases under PC Act.
Yes, sir.
Even presumption is there under the PC Act itself.
Yes, sir. Presumption is there in
and these are revertible presumption, and you have to revert it in the
trial. Every case filed under PC Act, you the 239 and the 227 is redundant.
No, no, not that. Not in legal activity.
Exactly, but we have shown.
Show me, you have demanded, show me, you have not accepted. From the record.
I'll show you.
If you show anything, either demand or acceptance is not there, then one can understand, yes. But show me whether demand is there and what is the allegation against you. If the allegation of demand is there and you have accepted it, is it not case accepted?
No,
it has to be proved.
It just not, I have not accepted. And at the time of 161 statement, they say something. At the time of 164 statement, they say something, they go back to those things and give a new case. So these things should be looked into.
Looked into at the right stage. We can't be contradiction in 161 and all that will be thrust out in the
it's not a contract, it's already moved. When you improve your case, when you improve and go by, it's not same thing. I mean, this is omission or commission. That is what my lordship see. I have given 161 statement, I have not given. 164 statement, I have given.
Saralagi, you are Saralagi.
64 statement, I have given.
Let us come to the charge sheet. What are the allegations against you and
charge under section only under section 7 of the PCI.
Yes, 7 of the PCI, yes.
Amendment Act.
Yes.
That's the PCI.
Yes, I'm there.
Once it is amended, it is PCI.
Yes.
Why they call it amendment, I don't know. Once after amendment, it is PCI.
PCI.
Present PCI.
Right.
My lord, your lordship see page 20.
Page 20.
Page 2.
Page 20.
And annexed to 164 statement.
Yes.
What?
How can you repeat another application?
You can base all this point and I'll sign.
I can't do that. I can't do that.
And that and this is the case, my lord. Watch, my lord said, why 239 and what's that, 227? That is only for 3 points. One is, if it is a crime escape, 228 takes care of it. If there's a network proportion, 227 said that. And the third point, when the Supreme Court said, if it is only a case of only substitution, then will also 227 that this application take on that. It's the case where it is disposed at great suspicions.
I think I should restrain passing any detailed order which may prejudice you in the trial. To you. To read all the points.
And these things are defense claim, and
I'll also record something. That the trial should be bit expedited. Correct. Right. The matter was heard at length. The petitioner is agreed by the order dated. Order dated 3/8/2024, whereby his application, her application under section 239 CRPC, reduced section 227 CRPC has been deleted. Next, the petitioner is accused in the back also. I have gone through the statement of cases recorded under the 151 CRP. 164 CRP. I'm not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to raise all the points at the appropriate stage of the trial. Regarding head to the nature of acquisition and the fact that the petitioner has constitutional and statutory rights of speedy fair and speedy trial, I expect the trial court to do that the trial is concluded as expeditiously as possible. And all the points are left open for raised by the petitioner accused and the appropriate. at the venue, at the stage of trial. With these observations, petition will be disposed. Thank you, sir. Yes.
24.
May I please your lordship?
Yes, madam.
Lordship, the NBW is exposed against the petitioner by learned HDGM Balasore on dated
Order dated? Yes.
2024, lordship.
Okay. 500, you pay 500. And if you honor before 20. Okay. 20. Will you give it to Malaysia? Give it to Malaysia District Court. Usually. Okay. 500. Yes.
25.
The individual was issued on 29/7/2019 manner and the subsequent execution 19 lordship.
Give 1,000. Yes.
26.
Who is up? I go back.
24, my lord. NBW was issued, my lord.
24.
Running page 28
28, 2022. 500. Yes.
27.
Oblige, my lord.
And there is incident 29, 5/22.
29, 8, 22. So 1,000 rupees.
Go to yeah? Go to
500. Okay, 500. Bar association. Yes.
28.
This is the case of rejection of 205 pieces. It is less than 4% suffering from
Complaint
So complaint is 205 and file a petition filing from Balasa district showroom and case is filed in Chandigarh.
Complaints for rules offenses.
138 of the NIA.
Okay.
So now the appear in PVC. He is suffering from his own man, he is suffering. 205 is to that has been rejected. I have not disputed my identity or anything like that. Usually correct is
I have been so notice.
so notice I have no problem.
You are already 70 years. 67.
Target surgery is suffer. You will travel 80 and 90 kilometers, you will travel to 80, that is there. And usually it's a
that usually we see.
Usually there is no dispute regarding my identity. And I in view of my
Anyway, I need to notice because I can't pass the order behind the back of the car. You should notice. File the process tomorrow. File the process tomorrow and we start in 1 week.
1 week?
NBW state. Execution of NBW issued on?
Issued
I said, what I do is
that is issued NBW 34 2020.
TVC charge. What I do is I am set aside this order and give you liberty to move press application under 205 and they give a direction that you will appear through which.
No problem.
Mishra will come with a complaint. Where is your application and 205? It is not rejected. It is not rejected.
My annexure 2, running test 12.
What are you impugning here?
I am challenging the rejection of order. That is the order dated 24/8.
No. 24, just see 24 order. 24 order. 24?
Running test 50. 24/8/2024.
This is the 205. This is 205. NBW will need to try.
That is I was suffering from cardiac bypass surgery. Where this NBW dispute in my locality, this is the whole difficulty. I cannot attend. And usually, in case of Vishwajit Mahapatra, this court has also direct after the choice of NBW marketing. It's a usual practice.
If you want to convert the state, then after 1 week, 2 weeks, after 2 weeks. Yes. What did you take amount?
20 lakhs. And that I want to wanted to sell land. He took money, part he just paid, the automatically dispute regarding giving and pay. That is the transaction. His son has in fact has taken money, he died. So he his father, come the money, paying the settlement, let the income, fixed installment and paying it up. He is also on that. Yes. Manor and below dated April 8, 2024.
24. Okay. 500.
Manor and below 1924.
500. Okay. Allow. Then how many of you are there? Only one, huh? One page. Okay.
My lords, NBW issued on 24/9/2024, my lords. Item 32, my lords, Belgium matter. My lords, NBW issued on 24/9/2024, that is page 11, my lords.
Okay, 500 increase. 500. Okay. Hello. I have updated information that my got a signal. It has not been reflected. What? Power one 1923. All of the union will be reflected. Conflict, okay. Yes. Last document, my lords, was granted bail. But the subject to verification of antecedent. When some antecedent found, my lord, the Consumer has not entertained. Against that order, I will file this. And where is my order? Hello, that was passed in. That was stated. That was stated, madam. 16 minutes. 307. Yes, 307. Where my lord, except the one, there is no scratch mark over dead body of the body of the any of the informant and gone. Yes, how many agents you have? As per regulation, the petitioner will be as per you will tell me. Petitioner will have given last proposal. Yes. My lord, just a minute, my lord. Simply I will submit 6 cases, my lord. As per my lord, the affidavit you have not filed. My lord, affidavit in the last case I have filed. Every case I have filed the affidavit. And after that, my lord says directed some other accused person to move after charge sheet. They filed before the tribunal and they released. There were 21 criminal antecedents. No, what he says is, insofar as doing are concerned, I have rejected the bail application saying that after charge sheet you apply. After charge sheet they apply, they will have the bail. Yes. All of them are having 2020 cases. Yes. So, if you have 7 cases, my lord, yes. Where are the 7 cases you are? My lord, reflected in the application have you said? Pardon? How many of you? 3. 3 of you. Sir, 3 of them, how many cases against them? Against petitioner number 1, the tribunal has reflected 2. Against petitioner number 2, there are 4 cases. And petitioner number 2, 1. Why in the rule application you have not said in all these things? Because it was reflected, my lord. My lord, in rule application, perhaps, can you have grant perhaps the pay or not apply?
Rejection, my lord, is 18. Assuming the fault could be left. And how many cases are there against him? 21 means Sudhi says 21. Will that? Sudhi, last day, that's still you are it. Yes, one being or on diagram, you say this thing that these three persons have been granted bail, they have been 20 incidents. So that I can record not face my I will petitioner is agreed by 23/9/2024, whereby the petitioner was the trial court was refused to release the petitioner on bail. Despite the fact that this court, by Rule 39/2022, the trial court refused to release the petitioners on bail. I will see. This absolutely other side. No, I'm not worried about that. You are correct. I'll record that and I'll tell you that's on the ground that the petitioner number one petitioner number one is involved in as per rejection 2 cases. Petition number 2, 4 cases is involved in 4 cases, and 3 is 1 case. Petition number 3 is involved in 1 case. All cases they are released on 1 case. Therefore, as per the condition laid down by this court, that subject to verification of incident, the trial court declined to release the petitioners. The account for the petitioner submits that in so far as the other 2 persons are concerned, they have also approached this court for grant of bail. This court also declined to grant bail, however, giving liberty to review the bail after the charge sheet is filed. But in the present case, charge sheet has already been filed. So, therefore, the 2 person had applied for the grant of bail before the trial court. The trial court, by the order dated 15/10/2024, enlarged those 2 persons on bail. That insofar as those 2 persons are concerned, they have more than 20 cases registered, despite having criminal antecedents. I mean, the 2 persons have already been granted bail. Therefore, the petitioner is entitled to the benefit of the concession of bail granted by this court by the order dated 13/9/2024 in BLAPL number 5199/2022. In view of the aforementioned development, the petitioner seeks to withdraw the petition to approach before the to move for the trial court for the release of the petitioner. To move the trial court. Such application shall be considered application of the pension receipt. The order dated 15/10/2022 passed. The trial court in BA number 894 of 2020. Yes, I can complete.
Connected case city is available. So, connected case will also dispose, right? Granted, let
it come after 1 let it be there for tomorrow. Let it be finished and there for tomorrow. I have some personal inconveniences. Day after tomorrow may not be a problem. And if you have to next week. I absolutely What is the urgency, sir?
For stay. Admission and stay.
Check it. Check. Yes, madam. Yes, please. What can be done? You give it, madam. I'll see you. What can be done? 138 meter dismiss.
Yes,
Where is the urgency?
Hello?
What is the urgency?
From last 2 months, it is 20, my lord, not coming in spite of now it has.
No, all the matters will come immediately within a week or so. Please give, I'll see that the matter is listed.
If not day after tomorrow, on 4th it may come.
Fourth. Okay. Okay. Yes.
So,
Yes.
attempt 40.
Attempt 14 one proper one time. Why are you asking for adjournment? Paragraph 4, my lord. One of the accused expired on 29/2012, my lord. In spite of that, FIR registered against him. Our matter. On request adjourned.
Instruction order.
Request adjourned. Yes.
60.
December, it will go to December. Yes. 16 years.
My lord, in this case, the petition challenging the passing of the criminal proceeding, my lord, which has been registered under section 376(2) and
Yes.
94, 506, 34, my lord.
Yes.
My lord, kindly see the FIR, the FIR story. There has happened on mutual consent, my lord. So both are major, my lord.
Charge sheet file.
Charge sheet file, my lord.
Charge sheet just see.
Charge sheet also submitted under section
372 N 294/506. Consent is a disputed fact
my lord.
to be ascertained in the trial only.
My lord. My lord, kindly see the FIR, my lord, for a moment, my lord. There is a long-standing law of affairs.
So that is good for bail.
Bail.
Apply for bail, you will get it bail. That is a ground for bail, not for quashing. If you from the allegation, if something is found that it may be a case of consent, you will get the bail. But how will you ask for quashing?
Surrender on the religion.
Your bail application is rejected. And never before this only got in the present case form. In the present form. Trick is in the present form. Your bail application is rejected already.
Surrender.
Your anticipated bail application rejected. That also you have not disclosed. You surrender. You tell me when will you surrender?
Within 1 month.
You surrender and resort to remedy under law. Okay. Right. Although the petitioner has challenged the entire criminal prosecution initiated against him for commission of alleged offence under section 376(2) N /294/506/34 IPC, but the counsel for the petitioner confines his prayer to confine his prayer limited to the confine the prayer for grant of bail. At the same time, the petitioner is also counsel for the petitioner also submitted that the anticipated bail plea moved by the petitioners has already been turned on by this court. In regard being yet to the same, I am not inclined to interfere in the present matter. However, liberty is granted to the petitioner to surrender before the surrender will appear before the court below on or before 20th
20th September, November, so and so, and resort to the remedy available to the under law. With this observation, the petition is disposed of. Yes. Next.
21.
I have done it twice.
May please oblige. Item number 21, my lord.
Yes.
In this case, your lordship, may kindly have a glance to page number 11. The FIR registered under 420, 467, 468, 294, 323, 123 of the IPC, my lord.
Yes.
What happened in this case, my lord? The petitioner purchased around 2.5 acres from the complainant, my lord, in the year 2022. I paid all the amounts since 2016 to 2022.
You purchased?
I purchased, the petitioner purchased. Thereafter, my lord, the land already transferred by paying all the amounts. I also paid the government stamp duty, your lordship. Thereafter, the ROI registered in my name. All of a sudden, the complainant filed a civil suit before the learned court below. That is, my lord, your lordship may kindly peruse.
Yes.
What is page number 96, civil suit number 212 of 2024.
Yes.
Lot of allegations are level in the civil suit, your lordship. The civil suit filed on 29 January 2024, my lord. After 2 years. Without getting any relief from that civil suit, she filed this criminal case, my lord.
Civil suit 150 of 2010.
She said that forcibly convert the land in our name. हमने land to forge करके हम नारे convert कर दी थी.
But a sale deed has been executed.
Executed, your lordship.
I expect the consideration and ROR has.
Yes, yes, lordship. Thereafter,
they made the influence of the appeal party.
Issue notice as civil disputation. Issue notice to the party, select level and so on.
Question is required.
What is this case?
No, my lord, investigation is going on.
Going on, I say. You are on bail?
Not bail. Protection may kindly do that. I will take the investigation.
They also dispose of.
No, my lord.
What
happened in this case, my lord? It is pure case of civil, my lord.
No, that's all these things you have to tell me. You will get the bail. Why are you not?
My lord, for that reason, my lord, I am referring.
Not case law is not required. Why you don't get
up, my lord?
You will get bail. What is the bail?
Bail is not important, my lord. The police will issue 41 also in this case.
That my lord,
what happened?
I am issuing notice. I am not notice. What date I am giving? You serve notice. I will.
No, no.
Returnable within 2 weeks. 11. I will be processed by tomorrow.
By.
Mr. Sahu wants to stay. This time can stay.
Yes. Yes.
This is the application for modification. Last application wanted to agree on the point. How the 37 can be over. Not right. Before going to that one, I have come to that question. Here is a case now. Earlier, indicated in the case of section 20 clearly in this side. And the punishment is at the lesser side. The petitioner was in bail. He is on bail.
Only one case.
Only one case, but that is not exactly similar to this offense, although under the NDPS Act. But there, this honorable court, after consideration of the allegation, there was that there was a plantation over a government land, and this petitioner somehow has been implicated by alleging that he was growing the plantation.
Okay.
So that is how the case was instituted and petitioner whether bail on that case, my lord, by the order of this honorable court. My lord, now this in the present case, my lord, if your lordship will kindly look at the allegation part, my lord. Allegation is that this petitioner was standing over a road, my lord, public road, my lord, and the police people they came and my lord, they found this man and they put taken into custody and repeatedly after asking, he disclosed that 2 bags he has kept by the side of the road for transportation purpose. That is the whole of the allegation, and on the basis of that matter, the petition has been implicated in the present case. So, your lordship.
Come to 37 first.
Hello?
Come to 37.
I'll come to 37. My lord, your lordship knows that 37 is a bar, my lord. Of course, my lord, if your lordship will kindly go.
That twin condition.
37. It is not a complete bar for your lordship to grant bail.
Right.
There is a restriction, no doubt, my lord. After hearing the giving an opportunity.
No. I some other point.
Yes.
Come to in your case, you are entitled to a grant. That is a different story. But come to 37.2.
And that apart also on the date of hearing and disclosed.
I understood. See, the similar antecedent. You say that the earlier case he was booked under 20. Section 20A. 20A, insofar as 20A is concerned, 37 bar doesn't operate. So therefore, it is not a similar case. I understood, I'll write that. But come to 37.2. 37 twin condition. Really?
If you want, there is no likelihood to commit similar type of offense. Then only.
Thank you. Lordship can impose the condition.
No. You see, Mr. Ravana is rightly read my mind. What he says in likelihood would be indicative of future offences.
Exactly.
Yes, sir.
So then how will you read this particular portion of the provision, second condition?
Yes, sir.
In the cases where the antecedent is already there.
Antecedent is already there, not of similar nature, but if you're not.
How will you read it?
But that he will not commit further offense.
That's what I'm. Do you have any judgment to that effect?
I understand. That weighs your lordship's mind that he may commit further offense. But your lordship.
It is a preventive kind of condition.
Very well important condition, my lord, that he will not. If he commits any further offense, the bail shall be cancelled or whatever.
So therefore, the condition which generally the courts are imposing, saying that look at the antecedent and thereafter you give the bail. A particular accused has already committed some offense. Can that be a bar operating under 37.2?
My humble submission before your lordship, it will not become a bar, my lord. Because, my lord, I'll just give one example. Supposing, my lord, a person is booked under section 307. My lord, there is another antecedent which is under section 325 or 326.
That is a similar case. Condition is similar case.
That is not a similar case. Therefore, your lordship is saying that if there is no similar.
No. Even similar case under NDPS, if there is already a case registered, whether in the twin condition is the 37 is bar.
37 says, my lord, the public will
read it.
I'm just
yes.
reading.
Where?
Notwithstanding anything content, I'm reading the entire thing.
Yes. Read 2. Twin condition is 2. Yes.
Where the public prosecutor opposes the application, the court is satisfied there are reasonable.
So 2 satisfaction is required.
For believing.
First satisfaction is a reasonable ground for believing that he is not guilty of the offence. First condition.
Not guilty of the offence.
Okay, from a side.
And that he is not likely
to commit
offence while on bail. So any offence means, my lord, here it is not exactly, my lord, similar offence. Any offence, my lord, he cannot be granted bail if the court believes that there is likelihood of committing further offence. Further offence of any nature.
Right.
That is a different.
That is while on bail.
While on bail.
That's what I'm saying.
So, my lord,
already he has committed. That's not operating again.
Yes. My lord, that has been committed.
So therefore,
there, my lord,
Therefore, after verification, the condition which I have imposed, that is not a condition akin to the requirement of 37(2).
Yes, sir.
That should be your argument.
That is the thing.
That is your argument.
That is the thing. And
I got some judgment.
judgment in the line that 37 so far as constitutional court is concerned, my lord. And your Lordship knows, my lord, that Muhammad Muslim case, my lord, the Honorable Apex Court has already expressed their great concern in relation to this restriction imposed under section 37, my lord, where they have said, my lord, the court, while considering an application in the context of 37 of the my lord Act, there should be, it should be considered in a very
Paragraph 20.
If your Lordship will kindly
The standard to be considered therefore is one where the court would look at the material in the broad manner and reasonably see whether the accused guilty may be proved. The judgment of this court have therefore emphasized that the satisfaction of which courts are expected to record, that is, that the accused may not be guilty in only prima facie case based on the reasonable reading, which does not call the meticulous examination of the material collected during investigation, such as grant bail on the ground of undue delay in trial. Here, undue delay in trial. Petitioner has already been admitted to bail by this court by order dated 13/9/2024 in BLAPL number 3977 of 2024. Subject to the condition, the bail order was the petitioner was enlarged on bail subject to various conditions, including a condition that after verification of the similar type of incident, he shall be released. He shall be released. The petitioner applied for release pursuant to the order of this court. The trial court, by the order dated 6/4/2024, refused to release the petitioner as the petitioner found involved in another case. Which is that case? Additional.
Yes, additional
being shown so.
TR number 11 of 21.
And TR number 11 of 21.
Corresponding to Bhutta Singh PS case number 10 of 2014.
10 of 2024 for alleged offence under section
20A of
2040. Agreed by the aforementioned order dated 6/4/2024, the petitioner has moved to
26/9/2024.
26/9/2024.
This is the order.
Okay, 26/9/2024. 26/9/2024. Agreed by the order dated 26/9/2024, the petitioner has moved the present application for modification of the condition imposed by this court while enlarging him on bail. Mr. Mishra, and counsel for the petitioner submits that the antecedent. The petitioner is involved in the earlier case for alleged offence under section 20A of NDPS Act. In the same case, the bar under 37 doesn't operate. Was not operating. Hence, he was enlarged on bail. Insofar as the present case is concerned, even under section 37(2), Roman 2, the second condition, the bar under the second condition will not come in his way because there is no likelihood of
the petitioner being involved in any other condition, and accordingly, a suitable condition could be imposed. Condition should be imposed. Taking into consideration the aforementioned, the petitioner, the condition number 5 imposed by this court by the order dated 13/9/2024 in BLAPL number 3977 of 24 is modified. And the petitioner modified to the effect that the petitioner shall not commit any offence while on tape. With this observation, the modification application is disposed of. Yes.
36.
Yes. This is my lord for modification of conditional losses. Well, granting there by the order that my lord 13/9/2024. 13/9/2024.
Yes.
Your lordship, important condition, my lord. He shall be released on bail subject to verification of criminal accusation.
Same problem. How many cases are there?
3 cases that has already been reflected in the rejection order, my lord. All those cases are political rivalry, due to political rivalry. But this case, my lord, 498-302, my lord, 498-302, subsequently gone to 306.
306.
My lord.
So the condition for the reason stated in the application, modification application.
My lord.
Modification application 1338 of 2024. The condition number 4 imposed by this court in order dated 13/9/2024 in BLAPL number 532420 of 24 is modified, and modified. The petitioner shall be released subject to undertaking that he shall not involved in any other criminal case while on bail.
37.
May I please, Your Lordship? May I please, Your Lordship?
Yes, sir.
So I am in custody since, Your Lordship, 21/11/2022. 21/11/2022.
Yes.
And in the meanwhile, Your Lordship, the material witnesses numbering 15 have already been examined. Those are eyewitness to the case. P-double 1, 2, 3 are the eyewitnesses. There is the informant and informant 2 minors child, Your Lordship.
Yes.
They all have been turned hostile, Your Lordship. 15 witnesses, Lordship, including the P-double 1, 2, 3. P-double 1 is the informant, P-double 2 and 3 is child, Your Lordship. They have been turned hostile.
Vital witnesses.
Your Lordship, they are the vital witnesses, Your Lordship. Rest of the witnesses, those are the official witnesses, Lordship. But this, Your Lordship, glance, the page number 17.
Yes.
Page number 17 of my internal page. This is the deposition of P-double 1, who is the informant of the case, Your Lordship.
Samir Madhya.
Samir Madhya is the petitioner, Your Lordship.
Yes.
Here the informant is also Urvashi Bostia. This is P-double 1, Your Lordship, page 17.
Have you seen it?
Turned hostile, Your Lordship.
The son and the wife who is the eyewitness, they have no turned hostile.
Son and
wife of the deceased.
Son, wife, daughter. Son, wife, daughter. P-double 1, 2, 3.
Most of the witnesses are material turned hostile.
All of them wait.
302. Last action, you will direct him to ascertain whether how many witnesses examined. This is so that 15 witnesses examined.
15 witnesses.
15 witnesses. And so far, the case have also obtained, my lord. Basing on the information of the wife, P-double 1, my lord, the case was registered and she is an eyewitness to the occurrence, my lord.
P-double 1,
my lord. She is an
wife of the deceased.
My lord, my lord.
Okay.
She also the informant in this case, my lord. She will turn hostile, my lord, during course of
Acha. And who are
and it's a son also, son of the deceased, my lord. He also turned
P-double 2.
No, my lord. We don't to another person, my lord. We don't.
Who is son of the deceased?
No, PWTA lordship is the PWP is also the
PWP,
PWP is
PWP is the son of the
Son of the deceased. They are the eyewitnesses.
not eyewitness, my lord. The wife is the eyewitness, but he has not supported the case, my lord. Son.
Total, how many witnesses are
Already 164 statement of the son of the deceased recorded, my lord. He has not time.
164? What is the
3-2, my lord. Allegation, my lord, on the date of occurrence, the petitioner and co-accused, my lord, assaulted the deceased went to inside the house, and inside the house, they again brought the deceased to the from the house and also assaulted in presence of the.
What is the relationship between the this deceased and the informant?
Dispute pertaining to 30,000.
In fact, allegation are serious, but since they are not supporting the case.
So total witness? Total number of witness?
Total
32.
15 are already been examined, madam.
And out of 15, how many witnesses have gone hostile?
Everybody LOC.
All the 15?
Yes, madam. All the 15 hostile LOC.
All the official, some of the official, they have not declared hostile, but they have not.
All the witnesses have done hostile.
All LOC.
Petition is accused also. And allegation against the petition the prosecution against the petitioner is also. There are 32 witnesses cited by the prosecution in the charge sheet. Out of them, 15 witnesses have been examined. Out of the 15 witnesses, many of them are vital witnesses. PW1 and PW3. PW1 is the informant and the wife of the deceased, and who is cited as a witness to the occurrence. PW3. Yes, PW3 is the son of.
Who also are the daughter, madam.
PW2 is the son of the.
PW2 daughter of the deceased.
Yes, PW3 is the son of the deceased, whose statement was recorded by the recorded under section 164 CRPC, and he too was cited as a vital witness by the prosecution. Whereas PW2 is the daughter of the deceased. Likewise, the other witnesses are also the vital witnesses to the prosecution. All the prosecution witnesses so far examined by the prosecution have resiled out of their earlier version given to the police. Therefore, the prosecution has declared them hostile and subjected them to extensive cross-examination under section 154 of Evidence Act. But nothing could be elucidated from these witnesses in the cross-examination by the prosecutor. Next order. Petitioner is in custody since last more than 2 years. That is from 21/11/2022. Since regarding here to the fact that the vital witnesses, including the eyewitnesses, have turned hostile in the present case, and petitioner is already incarcerated for more than 2 years, I'm inclined to enlarge the petitioner on bail, subject to conditions for an order.
164 statement also 1, 2 and 3 recorded.
164 the 164 statement of the eyewitnesses, namely the wife, son and daughter of the deceased, was recorded by the police during the investigation. Yes.
41.
Here I have filed a modification of the order dated 10/4/2024 passed by your lordship. The earlier.
Order. Where is that order?
I have quoted in the petition itself.
What quoted here?
At your lordship will find at page 2 para 3. I have quoted your entire order passed by your lordships. At page 2 para 3 your lordship.
What modification?
I have filed this modification for motivation of case number from ST case number special case number 18 of 2022, ST case number 9 by 18 of 2020. I have annexed annexure 4 to the petition. I have annexed annexure 4 to the petition. The order sheet wherein it has the case number. While I have been pursuant to the order of the Honorable Court, your lordship, while I moved for bail, I could know that there is a mistake in the order sheet and the case number has been wrongly reflected as a special case number 18 of 20.
Modification is allowed. In place of special case 18 of 2020, ST case ST case number 9/18/2020. And in view of the aforementioned confusion, the petitioner states that he could not surrender before the court below. Current surrender before the court accordingly seeks extension. In view for the reasons stated in the application, the petitioner is allowed to surrender before the court below on or before 20th of November 2021 and be sought to the remedy until law. Yes, allowed. Yes.
May I click?
Yes.
My lord, annexure 4, my lord, page 70. Earlier this petitioner was before this honorable court.
Yes.
As because all the documents have not been filed, your lordship are liberty to file a better petition.
Yes.
Page 70, my lord.
70?
My lord.
Yes. Yes.
That my lord, I have filed all the documents, FIR, the depositions,
yes,
and the others of the.
What do you want in this case?
Early completion of the trial. It is a case of 2015. Now we are in 2024. Only
the petitioner is seeking indulgence of the court for a direction to the trial court for early completion of the trial in CT case number 239 of 15 arising out of Dharamshala ES case number 4 of 2015 pending in the court of additional district administration judge. The next the present case is emanating from on FIR registered on registered on
7/1/2015.
7/1/2015 and the charge sheet file on
charge sheet file on
8/5/2015. Since then, the trial is
some of the witness exam, my lord.
No, I know.
Only one doctor.
Since then, the grievance of the petitioner is the petitioner has been facing trial since last more than 8 years. More than 8 years. Hence, he seeks indulgence. Hence, he seeks direction to the trial court to expedite disposal of the trial. Needless to mention that the petitioner being an accused in the aforementioned case has statutory and constitutional right of free, fair and speedy trial guaranteed under Constitution of India. Therefore, the prayer made by him in this petition deserves merit. Accordingly, the trial court is directed to do well to see that the trial is concluded as expeditiously as possible. With this observation, the petition is disposed of. Yes.
Only one witness and only one doctor.
Witness examined, my lord. 19 witnesses have already been examined.
One doctor actually. 2 years, 2 years, 2 years, Dr. Askonand. 2 years.
Are you able to witness?
Only doctor.
Only one witness left.
Mr. Raghunath, learned counsel for the
19 witnesses have been examined.
Mr. Raghunath, learned counsel for the petitioner, state submits that out of 20 witnesses, 19 witnesses have already been examined. Therefore, the apprehension of the petitioner that the trial will not be prolonged has no basis. To that, no basis. Mr. Polya, for the petitioner submits that the doctor who is cited as the last witness has been summoned multiple times, but because of his absence, his evidence could not be recorded, leading to the delay. In these premises, he seeks indulgence support.
Out of 26 witnesses, 19 examined, other 400
26 could 26 and 19. Yes. Next. Dispose of.
Extension of time.
Extension of time. Surrendering.
What is the affair?
9.
My prayer was it. And then the
for the reasons stated in the application is allowed. The petitioner is directed to appear or surrender before the court below on or before Kudi and resort to the remedy available to him under law as directed by this court. Wide order dated 14/5/2024. Yes. My lord, 44 and 45, may I pray that let it be taken to its after. 44 and 45. Request of the counsel for the petitioner, release the matter after the release matter. Yes.
46.
I have to take fresh notice.
So December yes.
I have to take fresh notice.
Fresh notice.
Yes.
Service on the opposite party number 2 could not be effected because
absent of absent किए रहूँ संजय लोगों ऐसे content petition में ताकि सही याद
because it is reported that the given address petitioner number 2 opposite party number 2 is not regarded. In that premises, Mr. Tripathi seeks one more opportunity to effect service on the opposite party number 2. He may file fresh requisites and fresh address to serve the opposite party number 2. Release the matter shown. So interim order granted on 28/9/2024 shall remain in operation till next date of date. Yes.
47.
47.
Private body.
So we have already obtained the certified copy of lordship. We will provide certified copy. The office will be collect the same, my lord. I have not inclined the same in authorized way. Because the CIL is there also, it is a type of appeal. So that would be the criminal revision.
That is a criminal revision only.
My lord.
Then
type of appeal is there.
Where is that?
That's it.
Which order?
Right.
Order the C1024. Order number 13.
Para 2.
My lord.
Para 2 is TRLMC revision over.
My lord. We will provide the certificate copy and office will be correct the same.
Give it.
My lord.
You take another certificate copy. What is the problem?
You also be direct to the copying system, they will have to rectify, my lord. Honestly, we have to
correct it and upload it. Take a fresh copy. This for the reasons stated in the modification application, the same is allowed, and the necessary correction and the order dated 3/10/2024 is carried out. I am full stop. Accordingly, in place of CRLMC found mention in the said order, CRLREB be mentioned.
We will provide the copy to the office, my lord.
Upload this in, please.
My lord, I have the copy, my lord. The certificate copy will
You one more. What is the problem?
how to apply the
Then
once we allow to the
subsequent order, it has to be, both the order has to be here.
no, what I am submitting, my lord. So once we direct to the copying section, they will record this, my lord.
Obviously, they will carry out the.
No application for the cutting or the
You can't apply for one more.
Why are you asking all these things?
I apply for one for more. What is the problem?
Yes, next. 49.
49.
Arjun to one capital minus 16 case. Arjun year 2016.
2016, why should you ask for apply? Adjournment.
While taking cognizance of court issued imbue, they have managed in past paragraph. The petitions are preferred this criminal miscase to recall the order of imbue issued against them. And the cognizance taken by order against them. And it's in
Where is the interim order? There is no interim order of stay.
whether they are in possession of it, they are carried out not manner that is not within.
Have you appeared before the court? The NBW issued against you was recalled. Thereafter, have you appeared?
No, not recall, my lord. My lord, the court will have taken cognizance against them, my lord, issued NBW directly, my lord. And against that, they have challenged this Honorable Court, my lord. The NBW year 2015, my lord. In the meantime, my lord, near about 9 years. Whether NBW executed or not, that is not within our, my lord. And liberty given, if not executed, then they appear before the court.
No, then the trial must be going on.
No instruction, my lord.
Trial must be going on. Because see, cognizance order is not state. Trial court proceeding is not state.
No, my lord. On the day, my lord, the cognizance taken, on that particular day, the NBW issued against it. Since such is something.
See, the order that 8/4/2016 order.
My lord.
It says that the NBW issued against the petitioner in GR case so and so Cutter shall not be executed till the next date of it.
Next date.
Where is the stay of this order?
8/4/2016, my lord. Stay out of there, my lord. For that reason, they not executed and not executed, my lord. Dispose of, my lord.
Well, petitioner is agreed by the order dated 28/9/2015, whereby the trial court, while taking cognizance of the offences under section, where is that order by? Where is that order? Nothing is filed.
In the 21, they are filed a variant for extension of interim.
Where is that order?
8/4/2016, my lord.
1 minute.
But the notice says that the IA for extension of interim order. In the 2021, they have filed, my lord.
1 minute. No problem.
In persons order, my lord, that order, my lord, of the apex court, my lord. The stay automatically vacate after 6 months. That
matters are always report pending, you know.
But that is not dispose.
Under section under section 341, under section 341 oblique 323 oblique 34 IPC, read section 3 of SC/ST Act. And also issued NBW against the accused person. Accused person for 28/10/2015. The next one, the petitioner received the aforementioned order dated 28/9/2015 by filing the present petition. While the interim order dated this court passed the following interim order on 8/4/2016. It has issue notice to the opposite party number 2 by registered post and AD, returnable within 4 weeks. Requisites which shall be filed by 12/4/2016. Next paragraph. NBW issued against the petitioner in GR case number 1784 of 1995 by the Lieutenant JMFC bracket R Cuttack shall not be executed till next date of listing. Next paragraph. It appears the matter, the present matter was it appears because of the aforementioned order, the NBW issued against the petitioner has not yet been executed.
Another thing that's another, they have also filed another IA, that is noting manner. IA number 171221, fact C, for external interim order today 8/4/2016.
In the absence of any specific order saying the trial court proceeding, this court, and I believe that the trial might have been proceeded. He is not appearing.
Proceed
it appears that the trial has not been stayed. However, due to absence of the petitioners from the court below, trial has not proceeded. In the light of the aforementioned, I am not inclined to adjourn the matter anymore. Rather, I grant liberty to the petitioner to appear before the court on or before 20th of November, and resort to the remedy available to them under law. And the trial court, in view of since the present matter is arising out of an FIR dated 26/12/1995. 95, and the petitioners have been avoiding participation in the proceeding. I feel it appropriate to direct the trial court to expedite the trial by issuing appropriate process to the accused persons. With this observation, the petition is disposed of. What is this going on? Just
directed to send the order of this court.
Yes, directed to send the order of this copy to 95 FIR. They were absconding. Thereafter, court took the cognizance and NBW was issued. They came to this court. 2016 taken stay. There is no stay of trial court proceeding. And jolly well. And now you are asking for adjournment. And these kind of cases, at least 1 lakh rupees cost should be imposed.
Lord, and share not available.
Oh, this is atrocious. This is not acceptable. Not acceptable. But I can't impose cost because it is the High Court which is not able to hear the matters. And conspicuously, these matters are never listed thereafter. And reasons everybody knows.
That's the last occasion
Therefore, I said them all the matter where the stay is operating, list it.
In fact, after the lots of direction on this kind of momentum and lot of matters whenever stays continuing.
Just see,
was taken up before
this is not a single time listed. This is yes, 50. Now the prosecutors have to also be responsible. You have to find out Which are the cases where stage operating matters are not listed?
That I mentioned.
You just find out and give the list so that we will get it listed. At least it should start rolling. Yes.
50 on behalf of Madam Jena, I am playing for only one password.
Password. What is this matter? I believe you are very competent. Why you ask me password?
Only one password.
Okay, password. This is also 2016 man. Okay, password.
In this case, my lord, I am appealing for the opposite party. I have no instruction in this matter.
Well, 16.
No, my lord. I don't
Madam K, Madam
50.
50, Madam K. Yes.
Selection calls. Earlier, the complaint case was filed. It was ended in single form. And on the said calls, once again, she filed another complaint case, which has been, which has given rise to PS case. So I am before your lordship for crossing of this error. And in the meantime,
Show me the earlier complaint and this complaint.
my lord, I have filed all.
Yes. Show me the earlier complaint.
FIR 12 to 29, page.
Yes. 5/12/2013.
My lord?
First FIR. And it's the one.
Yes.
What are the allegations?
My lord,
Who are you? You are
one more thing, my
Ashutosh
lord.
Patnaik, Sushant Kumar,
Santa Kumar Biswal is dead. And earlier, this honorable court was pleased to direct the state council to get instruction. What is the status of the case?
Was there any stay?
My lord, yes, stay was there.
Yes. Do you have any?
No, my lord, the instructions are for 16/2023, my lord. Since it is a year old course, my lord, that has instruction not come, my lord, about the status of the case, my lord.
See, so far as petitioner number 2 is concerned, he had died.
He is dead.
Yes.
Only 1 and 3 has to pursue the matter.
Yes. And complainant doesn't have any instruction.
And let's see, is actually what has happened, she is having some mental problem. That lady, for which one after another she filed the complaint case, FIR filed, ended in final form. In spite of it, she filed another complaint case.
You are questioning the second FIR?
Yes,
that is annexure 1.
Yes, my lord.
What are the offences? 420, 420.
420, 468. No,
Yes.
sorry. Yes, same, my lord. Offense, same.
Right on. Petitioner number 2 is stated to be certified to have expired. Expired. Therefore, the present petition is only press for petition number 1 and 3. Learned counsel for the informant opposite party number 2 states that he doesn't have any instruction. Mr. Raghav, learned counsel for the state seeks 1 week time to get the instruction regarding the present status of the case. Release the matter on 21st. 21st. 21st.
My lord, interim order to confirm.
And it is made clear. What is the nature of interim order, you see?
Interim order, my lord, your lordship may. No coercive action, I think so. Because it is of the year 2016.
No coercive action.
I think so, my lord. I am not sure. No.
My lord, 12/5/2016, my lord. It's a notice to the to stay further proceedings.
Proceeding.
By the time,
proceeding is stayed, no?
By the time when an investigation going on, my lord. But
then where is the proceeding?
Proceeding the time only if they are well in court below, my lord.
Investigation is not a proceeding.
No.
How it is stayed then?
Well, I'll take instruction, my lord. At the stage of the investigation or the charge sheet something.
Investigation must have been completed. Staying the further proceeding.
Further proceeding.
Where is the further proceeding in?
My lord.
12/5/2016. There shall be stay of further proceeding in CT case number.
Yes.
CT case, my lord.
CT, so by the time it must. Investigation is over.
You seek instruction.
Yes.
21st, it made clear that no further adjournment shall be granted in this matter.
Obvious.
Yes.
51.
one moves influence approach note. The second case notes. The second case is state case notes. The state has preferred the solution notes, challenging an audits by which discharge application was filed by the three accused persons involved in this case. The entire team of the first accused in this case was the bank manager of the cooperative bank notes. The second accused person was
May my lord, I am for the petitioner, my lord. I am for the one of the petitioner, my lord. I am appearing for a lawyer whose name is
I'm the
first case is the petitioner.
No, I'm pressing the second case. No?
In second case,
I'm pressing. Let me play it once. So small matters can be disposed. That case of 2016. There are three accused persons involved in this case. No?
Yes.
The first accused person is a gentleman as the bank manager of the balance notes. And the second accused note was the legal advisor of that particular bank notes. And the third accused was the beneficiary's notes, who got that loan notes. Now, notes in 2009 notes. In 2009 notes, the beneficiary of accused number 3 note got a advance loan, got a loan notes for a tractor loan of 5 lakhs under a farm modernization scheme notes. And notes the opposite party number 1, the bank manager and the legal advisor notes. Notes they in tandem notes connived with each others and facilitated this particular accused opposite partner 3 notes to get the benefits of 5 lakh rupees plus with interest note. After getting the agreement that loans note, he 11,000 were repaid. The rest amounts notes the accounts were declared as NPA, non-performing assets, and the sum was up to 6 lakh. So, state exchequer has suffered loss of 6 lakh 15,845 because of the connivance of the bank manager and the legal advisor notes, who, on the basis of concordant documents, concordance pertinent to the land records, on the basis of which note the loan was 5 lakhs rupees was released notes against forged land documents in connivance with opposition of 2 notes. The also clarified the position that the criteria number 565 and C24 have been recorded in the name of the officer are not genuine notes. Now, in this particular scenario notes, we can see that in orders notes, and this press reliance more. In these particular orders, ultimately, the learning special judge business valuation notes, what it did, we find to observe and the petitioner, all the 3 petitioners, at least persons were letter from the offenses under section 13 to 31B of the PT Act. So, for IPC provisions, concerned 409, 465, 467, 460, and 20B notes, they were found involved notes. Now, notes, I will just place 1 line notes. Notes can go to page 15 of the lordship book notes.
Yes.
In fact, it's starting from page 14 notes.
Yes. My lord, my friend, if my friend is arguing on merit, my lord, I am for the petitioner, I should be.
I'm testing the investment. Let others keep in the notes can turn to page 14 notes. Page 14. When it starts in second paragraph, as it works, let's just see the first 2 lines. The 4th line is the next question, whether everything also got it notes. The next question, whether any peculiar advantage has been obtained by the accused petitioner or not. In fact, page 14.
14 here.
15, I lost the second paragraph. It starts from as regards. As regards to evidence. Let's turn to the second line. The next question.
Page 15.
The next question. Let's turn to the second line. The next question starts.
Yes.
The next question, whether any peculiar advantage has been obtained by the accused petitioner or not. Because the question, and this is the ingredients of the section 13 1B notes. Now let's look at the findings for next page of the portion. The limitation of that last page of that note. It starts with that. So we will also get that number in the middle. So there is no ground for presuming that accused petitioners have committed an offense section 13 to 13 1B of the PCI, which explicitly the tribal religious group. We are forming the private charges, the process transfer of the program runs to who were in the malicious for trial on section 511, 465, 467, 122, etc. Now, that point that petitioner not invited is here. I listed one ground roads. First, you can turn to the ground road, ground number.
Yes.
Yes, number submission. I quoted the provisions of 13 day notes. She got it the ground number.
Yes, B. Page 8.
Page 8, ground notes. But 13 day notes which quoted here under for every
corrupt or illegal means of
offense for himself or any other person. This case for under this category of any other person's law. Now the bank manager, legal advisor, on the basis of the concordant documents, the advance loans, and the other persons benefited towards, even accepting the conclusion of the High Court notes. But still then the case falls under for any other person, including the beneficiary. So what in conclusion my submission notes, the 13(1)(d) are not confined to the persons obtaining peculiar advantage for themselves. But also a public person can be said to commit that particular offense of criminal misconduct. It also facilitates.
You say 13(1).
Yes, very much this particular
challenging the
IP is correct.
Yes.
And
yes, yes, Mr. Naik.
My lord, not audible. 60%. 70% submission is not audible to me, my lord. I am appearing for a lawyer, an advocate who is practicing in Soro Court, my lord, since last more than 15 years.
Yes.
And he was appointed as a penal lawyer of the bank. My lord, the bank applicant applied for a loan in the bank and it was processed. And as usual, my lord, the records were sent to the lawyers to examine and to submit a report regarding the genuineness of his title, my lord. The genuineness of the title, so for the land which will be mortgaged. That was the simple question which was asked to the lawyer, and the documents were placed before the concerned lawyer, my lord, by the party concerned, the beneficiary in the loan. So I, being a my lord penal lawyer of the bank, the document produced before me, the lawyer examined and found that the title is perfect, for which my lord the opinion was submitted that the title is perfect. It's no question of I have no jurisdiction, nor I am a document examiner, my lord. I
understood it. I'm listing it tomorrow because I'm hearing one of the similar matter tomorrow. Same lawyer.
I'm happy that
I'll just consider 5 minutes. What actually happened? There are 4 cases now. Why 4 cases? One scenario, one act, out of that, 2 positions found. One position is PC Act, which is trial by special judge. Other ingredients regarding the IPC to be tried by magistrate. So they clubbed together and started a trial. Matter went to special judge. Special judge, what he did,
I understood, sir. I read it right now.
How 4 cases have been filed?
I understood that also. I understood that, sir. Now the only question to be decided is, no. The only question that is to be decided is, if a lawyer gives an opinion on the basis of which loan is granted, the opinion or a verification of any document, he verifies the document, and those documents are false documents which has been accepted as a solid document. That part I see, if the error of judgment, then what will happen?
Yes.
And verification of document along with 120, what will happen? That is the issue I'm deciding tomorrow. So therefore I'm listing these 2 matters.
That has been answered.
Deciding those matters tomorrow.
Tomorrow, my lord.
Tomorrow,
my lord.
Next week,
my lord. I have some problem. Tomorrow, my lord, I have some problem.
Tomorrow I'm taking up because other connected matters are also there.
Next week, my lord.
Therefore I'm taking
those questions.
Yes.
I'll just make it there at least after 3 days.
Yes,
Because this factor, who knows what
I have
was-
also problem tomorrow.
Yeah.
I pay next week, my lord. And cyclone
Tomorrow, see, I'll simply list it tomorrow, but in so far as the larger question is concerned, I'll hear and I'll accommodate you tomorrow. No problem. Yes.
I will apologize.
53.
Yes.
Last occasion, your lordship direct the opposite party, complainant. Take instruction, it's a, well, that matter, 2005 marriage and 2007. 2008, both are separated in a registered document. So, other side, instruction, Mr. Patel. I talked to Mr. Patel in the morning. He said he could not contact his client. So he wants to take time, further time to take instruction.
On fifth. Keep it on fifth, on request. On fifth, yes.
Interim order continue.
2016 it is continuing for one reason or the other.
Your lordship kindly go to the other sheet. I have argued. Last occasion the matter was listed.
Anyway, I'll take it.
They have taken time for instruction, Balata.
Yes.
54.
Yes. Two 2013, 17. Two 2013, cognizance is taken. Before. Opposite party also further proceeding state and in 2016 further proceeding state.
Opposite party also appear when not appearance. Opposite party also appear.
Appeared, everybody is appeared for what to do. The petitioner has challenged the order dated 17/3/2013 passed by the Leonard SDJM S bracket S Katak in GR case number 411 of 2013, whereby the court below has taken cognizance of offences under section 498 capital A 34 IPC against the petitioner. This present matter is pending since 2016. While order dated 23/8/2016, this court this court passed the interim order staying the further proceeding in the GR case number 411 of 2023. The interim order is operating since then. Next, for non-appeals for the petitioner. In the interest of justice, he released the matter on Friday. Otherwise, at least, please.
55.
May I please go? In this case, as per my instruction, I have challenged the FIR. In the second case, the police has submitted final form saying that no offence is made out. But so far as the first and third case are concerned, I have not been able to take instruction. So if Lordship grant me 7 days time, I will take instruction. Because if those two cases also final form is submitted, then it is become infructuous.
No, this is how many cases you filed?
There are 3 cases. Even though the allegation was the same, identical allegation, there were 3 same leads. The complaint was raised that in the year 99, that without taking her consent, her brother had sold some land to third parties. I am the subsequent purchaser. I bought the land only in 2009. And allegation of fraud is of the 99 transaction. On that ground, I challenged the FIR in 2016, and there was an interim order not to take any coercive action against me. In the meantime, in the second case, the FIR police has submitted the final form. I have also got a copy of that.
Yes.
No offence is made.
Do you have any instruction, Mr. Vada?
Somebody appearing for the informant by that.
No, but these cases were filed at the time of investigation.
Yes.
And now one case, the closure report has been filed.
Yes, one case final form. I have given a copy also to my learned friend.
He has.
No. Filing.
Can I keep it on 7th?
I'll take instruction of because
6th or 7th, huh? Mr. Mishra, let the counsel the petitioner submits that out of the 3 cases, when it's entire contributed. अलग अलग केस बोला था ना अलग अलग ऑर्डर कर लिखिए अच्छा लिखिए जो 3 टाइम सेम ऑर्डर कर दिया आउट ऑफ द 3 cases in one of the cases the police after investigation has filed a closure report. He seeks 1 week time to get instruction regarding the other 2 FIRs. Other 2 FIRs, the investigation in the other 2 cases, FIRs. Need to matter on 6th. Entry mode to continue, it will make further clear that no further adjournment shall be granted. Yes, sir.
Oh, please.
My lord, item 56, I seek for an adjournment.
Adjournment. Entry mode is there. No, adjourned. December. Yes.
58.
May I please your loss?
Yes,
my lord. The order passed by the JNFC and the next 2 is under challenge, your lordship. Your lordship, and the court below. Taken in view that
yes,
the complete party number 1 shall be granted maintenance of rupees 15,000 per month.
Yes.
Your lordship, coming to the case, your lordship, and peruse my lord's annexure 1 at page 13 and 11 person I am placing, your lord.
You are the husband?
I am the husband, your lord.
15,000 rupees is directed to be paid to them. That's the final maintenance.
Final maintenance.
What is happening to your marriage?
My lord, kindly peruse annexure 1, your lord. Marriage was already dissolved. Yes, your lord. Why the matter was dissolved? Marriage was dissolved. I have to place before your lord. Kindly peruse annexure 1, and I am placing the annexure 1 from the start from the 13 and it is from the 15, your lordship. 15 page. Kindly peruse, I am placing.
Yes.
Last line, the last below to 1, 2, 3, 4, 5, 6. 6 line above, your lordship.
Yes.
In the meantime, he came to know about circulation of film depreciating a sexual act of Sunavada lady in the name of Chennai anti-sex scandal. This is your lordship. Thereafter, my lord, kindly peruse.
Yes.
I'm placing the first. At page 25, your lordship.
Who is involved in sex scandal?
My wife. My wife involved in sexual scandal, and that was my son.
Therefore, it was taken into consideration and divorce is granted.
With a order that judgment, your lordship. My lord, kindly peruse at page 34, your lordship.
34.
Yes. 34. Serial number 15.
Yes.
In view of the finding arrived in the issue number 1 to 6. And since the relief is declared by the petitioner has been decided and unsure, the petitioner is not entitled to any other relief accordingly. And this issue is unsure in view of such specific conclusion in meantime, it is hence ordered.
Yes.
The suit be and sent decreed on consent against the opposite party.
Yes, I understood. What happened to this decree? It has attained finality. No appeal was filed against that.
No, it was filed.
Then it attained finality.
Yes, sir.
Yes. Then
thereafter, my lord, after lapse of some day, your lordship, soon after the pronouncement of the judgment, this case was filed for a grant of maintenance.
In the same proceeding?
My lord.
Yes. Not verified.
My lord. And it was ordered to pay 15,000 rupees per month.
When the decree was passed,
Decree was passed. 27 day judgment and class and decree was passed. Decree for Petitions by C.
Yes.
So
yes.
Some day, your lordship.
Yes, I understood. Yes.
Your lordship. Now question is to be arise whether that lady
who was involved with the such conduct, claims is intended for the maintenance or not. So many decisions, my lord, is no, I'm submitting the case of my lord now. In case of Joseph Sain versus Respondent Union of India, wherein the case was decided, I'm placing your lordship. Blessing your lordship. Family, maintenance, section 30, sorry, my lord, it's another case. Here your lordship. Yes, in second page, serial number 1, this quote in this case question was concerned only with the validity of section 497 Indian Penal Code and section 192 of the Code of the Criminal Procedure 1973. However, it was agreed that section 497 Indian Penal Code and section 198 Code of Criminal Procedure were unconstitutional. The premise on which the provision was struck down was that the offense 14, 15 and 21 of Constitution. In this case, this court had no occasion whatsoever to consider the effect of provisions of the Act question. In fact, it was noted that it was not. Which paragraph you are reading? First para, your lords. Okay. First para, page number 2. Okay. Yes. In this case, this court had no occasion whatever to consider the effect of the provisions of the Act in question. In fact, it was noticed that it was not this court approved by the adultery. This court had found that adultery may be a moral approved of adultery. This court had found that adultery may be moral wrong. This court had also held that it will continue to be ground for scrutinizing the dissolution of marriage. It had also been described as a civil wrong. My lord, this is the one of the decision and yes, my lord, I filed the second decision, your lordship, whether that lady is entitled for the maintenance or not. My lord, yes, was decided by the Honorable Court of the Calcutta High Court of your lordship in the case of Sachin Kumar Vishwas versus Monomala Vishwas and others. Yes, here your lordship, the Honorable clearly mentioned that in first page, my lord, family. Attending section 13(1) and 25(3) of Hindu Marriage Act 1955 and section 18(3) of Hindu Adoption and Maternity. Same judgment again, my lord. Wherein he specifically mentioned, your lord. Which one you are reading now? Yeah, I'm giving second decision. Second, give that copy. Yes. In case of Sachidanand Vishwas, decided by the Honorable High Court of Calcutta. What is the ratio you tell me? Ratio, your lordship, the wife maintenance was drawn for the restriction. Further, under section 1, the wife is not entitled to get the maintenance if she unjust. While living in adultery, even during the penance of the suit, unjust mother not ideal burden for infants. Yes. Liberty says, I know.
You are submitting so many things, but one thing is ultimately forget here, I did not find it.
First, you answer one thing. The divorce decree was passed in the year 2021. That is 27/4/2021. The marriage is dissolved. And once the marriage is dissolved in 2023, how 125 application was maintainable?
That is maintainable.
That's what.
That is maintainable as per the rules and as per the judgment of Honorable Appellate Court. But the point which has been raised by my learned because so far as adultery is concerned, that has been not proved.
Not proved.
Lordship kindly permit the case.
That's the ground of divorce.
No, that is his ground, husband's ground. That has been not proved. That place lordship, that is the opinion of the learned court below. It is 33, 33, internal 21, paragraph 12. 33. My lord. Okay. Having in consideration the oral and documentary evidence adduced from the side of the petitioner, he is the petitioner. And the opposing party, obtaining the emphasis,
the petitioner and keeping in the view the requirement of the section 13(1) IA, IB, the Hindu Marriage Act,
Yes.
and the settled principle of law discussed herein before. In the following paragraph, it is held that petitioner failed to bring home the allegation that opposite party ever had the voluntary sexual intercourse with any person other than him. How could he say that? That is his sole ground. And second ground is, my lord, before this honorable court, that after divorce he is not entitled to get maintenance under 125 of this year. That is only two grounds he come before us. But so far as my lord honorable apex court judgment clerkship and rules, yes, it is maintainable even after divorce. Because if a person has not been filed at maintenance at the time of divorce, then what is the ultimate consequence? So cannot be.
Which paragraph? Which paragraph here?
Paragraph 12. That is.
Yes. Yes.
Last part is maintainable.
Yes.
That what he said that this order during.
Let us read it. The petitioner continues back to the maintenance has been allowed to respondent from the date of the application. The application number was filed by the respondent during the pendency of the civil suit. The application was filed during the pendency of the civil suit under section 31 of Hindu Marriage Act. And applicability of the maintenance from the date of institution of the suit, or that was the question in that case.
But in that period, honorable court has been exonerated.
I'm pressing your lordship. Page 33, my Leonard fund is suppressed. Something is not read before your lordship. Yes. 33 page.
Yes,
I will not read. No, देखो 33 page. No, last note, no, very good. No, only wanted to. Yes.
In the judgment which you have cited, it directly against you. Just read para 12. Read para 12.
The principle contains the rest that learning counsel for the petition that divorce having been passed, section 30.
Yes.
But the Hindu marriage on the ground that it is needed to
you read it.
Discharge, but by the respondent and for the maintenance would not have been passed in favor of the respondent the account of the section 4 of the 124. But 125 4 minor is added.
You are reading para 12 of the judgment which you cited.
Minor.
That judgment is Rota Singh.
Minor.
Reading para 12 once again. 1-2. Learned counsel for the petitioner.
Minor.
Reading.
My petition that contained that the maintenance has been allowed the respondent from the date of application. The application under 125 CRP has come by the respondent during pendency of the civil suit for divorce under section 13 of the Hindu Marriage Act. Since the content that says the degree of divorce has been passed on the ground of rejection by the respondent, she would not entitled to maintain the period of the passing of the decree section 13 of the Hindu Marriage Act. To that extent,
to that extent, the learned counsel for the appears to be correct. Appears to be correct. That's what the court says. To that extent, and you are entitled to the maintenance if the degree is passed. That's what the judgment is.
No, that part.
Why are you relying upon it?
No. The relying is the point which is the rate regarding maintainability to 125 per share.
That's what this court, the judgment which you have cited is against you.
That our case is, my lord. I may be sorry, my lord. I will say one thing. I will give the another judgment, my lord. Once the divorce, your divorce has been allowed by divorce, not adjourned.
Yes.
So, learning trial court has been passed the subsequent order that in maintenance case. Considering that the judgment of the Honorable Supreme Court, my lord, that I said a party in my lord, in Bharwal versus Kamla Devi case.
That is what you get.
My lord.
The one which you got is going against you.
No, that is not against me, my lord. That is not purely against me. The content.
Because the statute says once you withdraw from the company of a spouse, then you are not entitled to maintenance. So that is tantamount to the desertion. So therefore, court says that once you get the decree of divorce on the desertion,
then you are not entitled to maintenance.
So besides that, you have maintenance. Besides that, maintenance has been awarded in that case and petition has been dismissed. The whole thing has.
What was the ground of
ground? I beg pardon to my lord. The whole thing went before Honorable Apex Court against the judgment of Allahabad High Court. Allahabad High Court granted maintenance. That has been dismissed. That point has been observed, my lord. But here in the case, my learned friend's ground is only one ground is 125 is not maintenance.
What is the area now?
It as on that, my lord, 4 lakhs 35,000.
Why don't you settle? Pay some area and put an end to it.
My lord, my decide.
How much you can pay, you tell me. You also take, you are separated.
While out of court, I am saying, at the time of marriage, he is unemployed.
What about?
Sorry, because the unemployed. On my income, my source of income, she has been established subsequent after 6 years of my marriage. She has been.
Then indirectly you say that you have income. So then why are you offering?
No.
He depends on you.
No, she not particularly. No more than 7 more high
So how much you will pay? You tell me, finish it up.
Instruction
You take instruction. Take some money and finish it up. Let us close it like that.
I don't dispute about it. Lordship may dispute.
Once I decide means this the litigation will go on.
Lordship may dispose of with observation. She can take over.
No. Why should I go? Settlement, let him come. I will put it after 1 week. You come with instruction.
Yes, sir.
How much you can pay? On the lump sum, you take some lump sum and finish it up.
Fixed rate.
I am fixed. Yes. It's better that you pay. See, it is final it is a pendulum kind of situation. Some judgment in India, some judgment in India. Either he will go and the other will go.
Decide. Right.
You please come with some instruction.
Yes, sir.
So that let us put an end to it.
That is the problem.
Then therefore I am fixing a date. I will tell you when. And let it be fifth and fifth. You come with complete instruction, how much you will pay, and don't offer some amount which is insulting. Okay. And give some amount so that we will make his client, and
interim order will continue.
Interim order will continue. Interim order will continue.
Fifth line.
Put an end to it. See, he will go.
Yes, sir.
To the higher court. He will go on. Yes.
59.
Yes.
59 opposite party number. Time to file the
And this is a 2023 matter. It is pending from October 2023.
Now she has received in notice again notice after he has absent.
What is this case, by the way?
This is regarding challenging the petitioner is the brother-in-law.
DVA.
Divorce has been allowed. 498 acres has been dismissed. Nothing remains, my lord. Maintenance has been disallowed by this honorable court.
The so-and-so entered its appearance on behalf of opposite party number 2.
Opposite party join again.
Opposite party seeks 1 week adjournment is the last opportunity to file wakalatnama and response to the present petition. By way of last and final opportunity, 1 week time is granted. Lease the matter on 8th of November for final disposal. It is made clear that no further adjournments are not granted. No further adjournment will be granted. Yes. Everything is over. Interim to continue. Everything is over. Then into it.
498 filed against husband is dismissed.
Then
brother-in-law. Maintenance case is disallowed by this.
Separated also.
Divorce allowed. And brother-in-law is dragged in.
Why are you after the brother-in-law? You could not do anything to the husband. 498 exonerated, divorce granted.
Judgment I have got. Judgment I have got.
Leave the brother-in-law at least. Let him leave peacefully. Yes.
60.
Yes.
Last time I think everything was complete. So and we are stuck up at that point whether that order has been challenged in the Supreme Court or not. So the studies are there. Basically. And
Let me under. I just.
as far as that is concerned, okay. I have filed this petition to section 6 of OPAD Act.
Okay.
In that, I have already submitted the written argument, the date chart, everything is.
Yes.
As far as this is concerned, this case, the base of the case is that against the same petitioner and the same company. If previously in the year 2012 a case was registered, subsequently 6 of OPAD Act has been passed from that one. In the year 2019, another case was instituted by order of this Honorable High Court. However, challenging that order, we came to the High Court and High Court passed that, didn't pass that order, but directed that charge sheet which has been filed in this case in 2019 to be a part of the previous one, which case has been registered in the 2014. And again, that order, state went to Supreme Court. And Supreme Court said, no, that will be a separate case. When that becomes a separate case, after 5 years, that becomes a separate case. We have applied for to pass the sections of 6 of OPAD Act, basing on that previous order, in which that
Section 6 has been dropped.
That was that. And the state, yes, raised one time. Night also.
It has not been dropped. That with the particular case, my lord.
It's pending.
That is pending. That is pending. Then, my lord.
Now, relying upon Rasmita Patra, insofar as this petition is concerned, in that case also, Section 6 is dropped.
This case, my lord.
Now, this case is not dropped. Therefore, he says that drop. The earlier case, see, here 2 FIR. In 2013, 1 FIR. And in that case, Section 6 you have invoked. Relying upon Rasmita Patra, Section 6 is dropped in that case, the earlier case. Subsequently, in another case, the present case is reached. Here also, Section 6 you have invoked. What he says that relying upon Rasmita Patra and earlier case, insofar as he is concerned, Section 6 should be dropped in this case also.
No.
That's his case.
No. When, my lord, Rasmita Patra case was stayed by Honorable Apex Court, my lord. After, my lord, the result of the Apex Court, my lord, thereafter the further applicable or not, my lord, that will be decided, my lord. Then, my lord.
In Rasmita Patra's case, Supreme Court has stayed the impugn order.
Yes.
No.
Yes, my lord. Yes.
God.
Can you have a class, my lord?
Assuming that
Yes,
if the Supreme Court has not stayed the impugn order, what is holding the field today?
No.
Yes.
We have that. Let's see.
Yes.
Stay then that the judgment of this High Court is not holding the field.
It is not with me. Let it come, my lord, next week. I'll
No, call Bhargav. Bhargav 2107. Yes, ठीक है Bhargav sang Bhargav. अच्छी के can I know Bhargav?
Next week আসছে কত কাটিব হার্ড কপি দাও আর বার করবে নেক্সট উইক আসছে
ঠিক আছে 8th রাখতে 8th
I want to কথা কি Night overstress, that the submission was over. Fine, Bhargav 210. Lingering करी more what what I say, whatever the result. Again, I am repeating that. Whatever be the result, if it goes in favor of us, state will go to Supreme Court. If it is against us, we will go to Supreme Court. It is because the connected matter is pending before the Supreme Court.
You want to go to Supreme Court? Because I just want to know whether the High Court order, if it is not stayed by the Supreme Court, that holds the field, you are covered by that. Exactly. And relying upon that, you are going to go to Supreme Court. Then nothing is holding the field today. What can I do? I have to independently pass an order.
One minute. Just a minute.
There are many orders. You don't know. Only one. I know there are many orders. one Justice Patnaik's order, Peringuriam is also gone.
That has been challenged by the state. Okay, what he says in that order has been stayed. Okay. You take care of it.
I'll just pass it over. If you can get it, it's all.
No, sign on.
Yes.
61. Petitioner the referred lords, Vijay Kumar Malik and Ajit Kumar Bhatt.
Yes.
We are just giving a short list of dates.
Mr. Mishra complex it. I'll answer tomorrow, but 10 minutes tomorrow. Let him start.
It is against discharge.
Taking discharge. Then just let's the list of dates.
Just run through the list of it.
2008, tender was published for renovation of 9 different drainage channels in Chandrapur and Bhadra drainage village.
Yes.
There in annexure 1. 29/10/2008, tender papers were opened and comparative statement was prepared, and since there was only one bidder in respect of the work, white serial number 1, the tender notice at annexure 1. Official processes were started for finalization of the tender.
Yes.
29/1/2009, read petitions were filed challenging the opposite tender process, and this honorable court directed for vigilance and inquiry while order dated 29/1/2009 and 4/2/2009, respectively, and finally disposed of the same while orders were. Copy of the order we have given along with the.
Yes.
The High Court basically directed that to cancel the tender process.
Yes.
24/4/2009, Ganeshwar Sethi DSP Vigilance conducted inquiry and an FIR was registered as Ganeshwar so and so against Tapas Chandra Samant. He is the chief engineer, and Vijay Kumar Das and Hiro Kumar Mishra. Take note of these names. Tapas Chandra Samant, Vijay Kumar Das.
Tapas Samant.
Vijay Kumar Das and
Hiro Mishra. Who are you? You are.
You were not there in the initial election.
You are Bipin Kumar and
Bipin Kumar Malik and Ajit Kumar Bhatt.
Bipin Ajit.
So on 24/4/2009, FIR was against these people. High Court order also mentions the names of the actors. We were not there in that order. Next date, my lord, is very important. 28/9/2010. Director Vigilance, by letter dated so and so, asked IO to place charge sheet under so and so against Vijay Kumar Das, Hiro Kumar Mishra, Tapas Samanta, Chief Engineer, and Ganesh Guru DA.
Again, name is not there.
Again, name is not there. Now, this is very important. This document, I will make kindly see at Annexure 3, page 25.
Yes. Yes.
I'm so sorry. Annexure 3, page number is 27. Associate.
Yes.
The director's note.
Yes.
I'm sorry, my lord, that page number they have made a mistake.
Page 27. This is 27. Page 27. Okay. Yes.
I'm kindly see.
To verify whether a
28/9/2010. I hope the date is correct.
28/9/2010. Correct. Yes.
after the note of the IG or police vigilance, my lord may see. Investigation is complete and it is nearly 1 year and 6 months old. Hence, we may ask the IO to place charge sheet so and so.
Against so and so.
Against Vijay Das, Vijay Kumar Das,
Your name is not there, I think. None of you. Also, name is not there.
Both names are not there.
Yes.
And this is a note of the director of vigilance, the highest authority. This is what the director of vigilance knows. That is crucial.
But the second paragraph may assume little importance.
If the accused would have moved the
The RDA be recommended against the Ashok Kumar Naik.
Mishra and Rajendra Kumar for the misconduct.
You are one of them, Ashok Kumar. Ashok Kumar.
No, Ashok Kumar Naik. Petitioner is
Here?
Ajit Kumar Behra.
Ajit, okay. Also, they are also not there.
Not
Okay.
there.
Okay.
So this is a crucial document. Director Vigilance notes this. Thereafter in 2013, after almost 3.5 years from this date, the IO begins another investigation. And in that original, that's at serial number 6 of my list of dates, he initiates a fresh FIR on the self-same issue against Nora Harikonda draftsman, Ajit Kumar Behra, my name that is, Vipin Malik, that is petitioner number 1, Hirod Mishra, Vijay Kumar Das, Ganesh Guru, and Ramesh Chandra Biswal contract.
Yes.
So what is crucial here is, as it happens most of the time, the chief engineer is dropped. And in the course of my submissions, I will show that he was the ultimate person who had approved.
Okay.
So they are going after minions here. So another FIR is lodged after 4 years and 7 new people are added. Now in this context, what would be important would be order number 9 dated 2/5/2018 passed by this court in this criminal division. Wherein this court formulated 3 questions after hearing.
Yes.
Against whom first charge sheet was filed and I'm facing towards the bottom of that order.
In the respect of policy of vigilance case number 17 of 2019.
Inquiry in relation to 9 items and in any result is found out in respect of specific item for which policy of vigilance case was registered. 3. The basic difference between the first case and second case and the necessity of registering the second case. The matter could have been inquired into in the course of investigation in the first.
Yes.
Now, thereafter, my lord may kindly see. Against 7 people, they started fresh investigation and then ultimately submitted charge sheet on 25/6/2015 against 5 people.
Yes.
That is
including you.
Including both of us. Ajit Kumar Behra, Vipin Kumar Malik, the 2 petitioners, Nora Harikonda, Vijay Kumar Das, and Ramesh Chandra Biswal.
Hirod and Ganesh will drop. And these 2 persons were in that earlier FIR.
No, in the earlier FIR, the vigilance director didn't, his note didn't contain this.
No.
His note contained
Hirod also there. Hirod
and Ganesh.
Yes, their name is there.
Hirod was there, but he subsequently has been dropped.
That's right.
Now, if my
Hirod was there in 2010 noting. Despite that, he has been dropped.
Yes.
If your name were not there, you have been routing.
Now, my lord may kindly see what was our role in this tender. Under RTI, we have got that document. The entire note sheet we have got by way of RTI. The original is a part of the court record.
Yes.
Additional affidavit filed by us.
Yes.
And page 74 of that note sheet is my lord books. For the handwritten note sheets, we are giving typed copies. Just for the convenience of the court, my lord may refer to both.
Additional affidavit.
Yes.
My lord would see that my lord may take it both side by side. This is 74 of that additional.
74. Yes.
Now here if you also see. The first note is of Naravari context. At page 74.
74 additional affidavit.
My lords. Running page 74 of the additional affidavit. Notes as above may be perused in continuation to office letter so and so. The financial field of C. Vishwa, special gas contractor is opened on due date. Rates quoted by C. Vishwa being single entity is incorporated upfront. So after checking the amount of C. Vishwa, it comes to 1,27,67,000 being 5.98% less than the amount put to tender.
51. Anyway, yeah, you read from here. I'm not able to get it. Yes, definitions are difficult. Yes. Where are you reading?
My lord is referring to the type copy or the
Yes, I got it now. Yes. Yes. Type copy.
First note is of.
What do you want to show out of this?
My lord, I want to show two things. First is that if your lordship says takes the case of Bipin Mali, his note at that page, my lord, is.
If these documents are part of the charge sheet?
Yes, discharge order itself takes note of this note sheet. The impugned order before this court takes note of this, and this is a part of the record. I'm not submitting beyond the record.
No, this is part of charge sheet.
My lord knows that even if it is not a part of charge sheet, in terms of the DN party, documents of unimpeachable character can be gone.
For it.
In any case, the impugned order.
But at the same time, the official noting, which has not ultimately culminated into the final order.
No, it has culminated.
Culminated to what? This is a tender process. Some official notings are there. Okay. I have to read the tender.
Now, my lord, kindly see what has happened. It's a case of single tender. My role here in this, just one noting, is that I have said that it's a case of single tender put up for approval. I have not recommended, I have not said yes, I have not said no, nothing.
Who are you?
Bipin Mali.
No, what is your position? You are working at what? Bipin Malik is what?
Bipin Malik, at that time he was the assistant executive engineer. So he is much deeper in the.
See, very tactfully the notes are being drafted. Single bidding. It's a case for first bidding. Why have you?
That's the reason why I am showing only Bipin Malik's case.
Let us see the noting. How he is noted.
74.
74, yes.
There are three notings.
Yes.
First one is of Naravari Panda. He is not before your lordship. Second one is of Ajit Kumar Behra, wherein he has given some recommendation. Now, third noting, my lord.
Ajit Behra is one of the. Yes.
Now, third noting of that page, my lord, kindness. If my lord is seeing the.
Yes. The type copy I am seeing.
Type copy.
Notes says above.
Notes are clearly seen. The tender of single responsive bidder. Now, single is underlined.
Yes.
If my lord see the original single is underlined. That underlining is very important, and this is by one of the petitioners. He simply says the tender of single responsive bidder, special gas contractor being so and so less than amount to tender may be submitted to chief engineer.
Why have you forwarded it? In a single tender.
Single tender.
You are an executive engineer.
Assistant executive.
Then it started. The movement started from here.
And ultimately, my lord, he has simply said, because the OPWD code says that if it is a single tender, it has to go for approval.
For fresh tender.
For whatever, for fresh tender, for analysis, or for, because if additional costs are involved.
It never goes for approval. It goes for approval for the fresh tender.
No.
Show me the.
That is not the vigilance case that by the single tender or process.
That's
the case here is, I will tell my about the prosecution case. Prosecution case is that originally there was an excess, a less amount to the tune of 16.so-and-so%.
Yes.
Which is higher than 10%. The moment it is higher than 10%, APS is required, additional performance security.
Right.
The case of the vigilance department is that this 16% was later on overwritten and brought down to 5.98%, and hence this overwriting is a misconduct. This is the basic case of the vigilance.
And manipulated tender papers.
Manipulated tender papers, this overwriting is done by.
And you, what are you writing then? Just see, being 5.98 is less than amount, but you are authenticating that 9.58. 5.98. You are authenticating that.
See, the amount is given 1,27,67,000. This is actually 5.9. Mathematically, this 5.9 figure is correct. That also they admit. But they say that originally it was 16 and you have overwritten and made it 5.9.
Yes.
And in any case, so far as between Malik is concerned,
yes,
there is absolutely nothing. He has neither recommended for APS or giving back of APS. He has simply said that it is put before the scene. Now what they do, 2 pages thereafter, the person who recommends the tender, he is thrown out. He is no longer a part of the investigation. The director says that to make him an accused, he is given. Go by. Next page, my lord, may see the approval.
Yes.
So that means just because I am just at the lowest rung of the ladder, they train bars against me, and the main person is left out irrespective of the director's recommendation.
That 319 is there. If non-inclusion of the one of the issues,
319 chapter is closed.
That 319 will be invoked insofar as that main accused is concerned, who has been dropped. Maybe, I don't know.
This is
that will not preclude the prosecution to.
This is telltale. The director gives a rock solid recommendation that you submit a charge sheet in these forms. I am nowhere in the picture at that stage, and rightly so, because there is nothing against you. A person says, and my lords, when only see that underlining, I would lay more emphasis on that. He has said that this is a case of fingertip. And as per the, and their case is not that by the single tender of process. That is not the vigilance case. Otherwise, I would not have pushed this before your lordship. Their case is not that by a single tender of recommended by BP money. Had that been the case, I wouldn't have been before your lordship. So, my lord, so far as BP money is concerned, there is absolutely nothing. And I have 2 Supreme Court recent judgments of Justice Narasimha and another one of Justice Augustine George Mercy, my lords, where they say that if no prima facie case is there, it's a good case for discharge. And my lords, I am before your lordship at the fag end. This is not cognizance. I am at the discharge.
Yes.
So, my lord, so far as BP Malik, I have a rock solid case because this underlining, I am repeating, my lord, this underlining is very important. He puts up this is a case of single tender, he underlines. My lord, may see the RTI document also, because this is type, they may always question. The RTI document which we have produced, that also contains that underline. He has said that.
Where is that original one?
The original RTI we have given with the code with additional affidavit, page 74. That's the reason that in the beginning I mentioned that my lord may take both of them side by side.
No, I am there, exactly there. That underline I can see it, but what kind of underline?
Original also my lord will see. That original. At flag. So if this is the way managers will prosecute government servant, then they will not do anything. He is just.
They got sanction also.
Sanction, I don't know how sanction is got.
The same officer, those who have said they have given sanction for prosecuting.
Sanction, I don't know how it comes. Page 74, the original RTI.
74, yes, there.
Page 70. And my lord, see that underlining.
Same thing.
My lord, this underlining is something which is very important so far as between money is concerned.
I don't know whether he has underlined or the approving authority is underlined. Who knows it? I don't know. But small underline on that basis, I can decide the criminal case of this nature. I don't know while approving that approval authority might have underlined. How do I know?
My lord, we ignore the underline. My lord, we just see the note on a standalone basis.
No, note I can understand.
The case of the prosecution is concerned, so far as Bipin Malik is concerned, there is absolutely nothing. So
are you not pressing on for Bipin Malik only?
Bipin Malik, I am saying, unless he has a watertight case. So far as Ajit.
Sir, I record it that you are pressing for.
I'm making the submission that Bipin Malik has the strongest case between the two. I'm being fair across the board.
Yes. But this is one point. Next.
And this is the strongest one. Yes. This note is this much only.
Yes.
And my lord, may kindly see thereafter.
This note eventually got approved by the highest authority who has been dropped, despite the fact that the director of vigilance says that he is responsible. That is what your case is. Yes.
Suppose the final authority approves and ultimately you don't find him guilty, then this is claiming guns against the minions.
Okay.
And he is much below in the ladder. And the original note didn't begin from him. That is also one thing your lordship may kindly take note. The original, had he been the original creator of this, then things would have been different.
Yes.
This note didn't begin from Bipin Malik. And he is much below in the ladder. Now, his entire, this is not a case where I have to face trial. His entire career is at stake here.
No, the consequences are serious. Yes.
And it is only in this background that this court formulated that question.
The senior most officer who has been generated, for him the sanction was sought. Whether the sanction was sought?
But
the officer, because see
the additional corporate notes are there.
The Director General has taken the name of that gentleman, the superintendent engineer, whoever it is, the highest approval authority. So, have you, chief engineer. What is his name? Chief engineer's name?
Tapas
Saman. Just see, if you see page 27.
The copy is not with me, I will collect it. I will collect another one.
Page 27, what is Saman? Tapas Samanto.
Bring something out of nature. No, packing my work.
No, might not be interesting to see.
If the IG of police, DG of police, rather, DG of police, director police, vigilance, has specifically written that you can proceed against Tapas Samanto, along with other, for this offence. And the prosecution might have applied for the sanction, whether the sanction was granted. Despite the fact that sanction is granted, if you have not filed against him, and I think he has a case. If you have not applied for sanction at all, then why he was sanction was not sought? And when the sanction, insofar as this accused is concerned, you have sought after this noting immediately, or after 3 years. These things are very important. Because if these are, then there is apparent case of modified prosecution against him.
Notice that.
Then in that case,
somebody is a protector, somebody is scapegoat.
The lesser.
Yes.
The document would be at page 77, if you also can see either the original or the digitized version. The approval is granted by Tapas Saman post-fact.
77?
Yes.
Yes.
Approved post-fact.
77 of the noting.
Yes, top first noting, approved, his handwriting is there, approved post file. And the entire note says that the chief engineer is to give the approval.
Which may be approved for. So his involvement is whether he is involved or not is a secondary issue. The primary issue is the Samanta is directly involved and his name also the director takes. Whether he sought for sanction or not.
I will just, I will get that copy, I will get instruction whether.
After exposing against him, if you don't even ask for sanction and you try to prosecute someone else, actually malicious.
When the head of the department, what it says correctly, when these are the persons who shall.
Very specific.
And if are not short for the sanction from the.
Can you approve post facto? And no doubt the file starts from him. No doubt.
Not from me.
Anyway, you file starts from you only.
No.
Yes. You are the technical head, engineer, and the rest of the people are the.
I'm
1 minute. Then who all are they?
Normally, Ponda it begins from page 7.
Who is Narari Ponda?
He is one of the applicants.
No, I know what is he? Yes, you are the engineer, first engineer.
No, my lord, if your lordship wants to go into that, the original proposal came from SCDC BLS, that is Vijay Kumar Das. He is the higher authority. The original.
Who has put the note?
It is SCD BLS.
Yeah, I want to see it is how has it distributed. The body has been distributed.
My lord, let me make one.
That's what
Let me make one thing very clear. So far as this Vijay Malik is concerned, there is Vipin Malik. There is absolutely nothing. This note of his is just saying single tender. He has not recommended for release of APS. He has not recommended that the tender be out. So that's why I began with my strongest candidate. And the other person, there is a recommendation so far as APS is concerned. But so far as Vipin Malik, he is much, my lord, will get it from his name also. He has been an innocent person.
What happened to departmental proceedings?
No recommendation so far as Vipin Malik is concerned.
No. What about the other? Any departmental proceedings is not against him?
Against him, no departmental, but all his career movement has stopped, and he has a spotless record. Manage. Only this one noting is what is there against. And he has not recommended it.
Manipulating tender papers.
No, he has not manipulated.
Anyway, that's a finding into complaints.
No. He has not manipulated. Manipulation might have been done by the contractor level. But he has put this noting. In the noting, two things he says. One is, in the single, when the word single is written, he underlines it, emphasizes it, highlighted it. He is alive to the fact that it is a single tender, and he submitted it to the executive engineer, chief engineer, for the popular approval. And the chief engineer approves it post facto. And the same chief engineer was recommended by the director vigilance to be proceeded with by not taking the name of his client. Then in the face of this, why have you either sought for sanction of chief engineer to be prosecuted? How do you exonerate?
Right.
Right. Some engineer wants to.
The usual process the chief engineer accepts. Why not?
You tell me that.
And the IO overnight the orders of the director of vigilance. He is the head of the director.
And what next is, what was the occasion for registering the FIR at the subsequent stage at 220-30? What was the next stage?
Subsequently,
all these things you have to answer.
But one thing is that those documents on which so many submissions have been made notes, but those things are part of the charge sheet, the material produced by the prosecution at the time of judicial application note. Because all these arguments of the plea should be in consonance with the material produced by the prosecution, not beyond that.
But I tell you, my view is, if you are building up a case against someone, if you deliberately
don't make part of the charge sheet in an obvious document. If for the entire case of your case, he has recommended this is an obvious document. You should have made part of it. If you have not made part of it, the court can go into it.
No, in fact,
Your entire case went up on this.
I need not.
You don't make part of it.
I need not. Those things which have been held by the prosecution as per the accused panel. Accused has always can resort to the other mechanism. To place all the.
No. My case is, what I'm trying to say is something different. If your entire case is built up on the basis of a particular document, prosecution case, deliberately what generally IOs are doing is, that document will not file with the charge sheet. And but in the narration, they will say everything about that document. When he files for discharge or something, and the prosecutor will say, no, this document is not from part of it, so don't consider it. No, that document.
Which pertains to the material produced by the prosecution.
Obvious document has to be there on the part of record.
Yes, but
So if obvious documents are not there, then the court can go on to the obvious document.
please pertaining to the
That's the night.
not only the materials, any please also permissible, but that's should probably exempt then.
You please do. Tomorrow he is not there. I don't want to waste much time here. I understood it now. Now you.
But now this whole premise is a case of 2018, Lord. I am also equally concerned the stage operating. Lord.
Then you tell me when.
I will get the information from the IOM laws.
Six. Part third, six. Entry want to continue. Yeah. Can I take it tomorrow because I have a meeting? Yeah. Yes, sir. Tomorrow can I take Das
Remove hard copy and put the revision stage.
So state of the to try, yeah.
There shall be a stay of operation of the interim order passed by this High Court for a period of 4 weeks.
I know.
Just 4 weeks, is it infinitive?
Yes.
After 4 weeks,
That continues.
not many days come up.
That continues. Continues. That's
That is so. If that is so, then they don't give date.
4 weeks, 3 weeks, 3 weeks, 7 weeks.
4 weeks for it.
It doesn't go automatically.
They do not ask for extension. However, doesn't mean the lawsuit that goes against to person out. My submission point is everyone in each order has been challenged.
Have you already booked the ticket for the news?
That is not the point.
I'll list it on two.
Miller.
Took at 3 o'clock.
Miller.
Mr. Pagda is on the virtue modes.
Yes, sir. 62. Tomorrow. Spill over to tomorrow. Huh? Okay. Can I fix it on 25th if you do mind?
25th actually I have to go to Berhampur Millers.
25th, nobody knows where who will go where.
I don't know. I told the sessions judge today, but the sessions judge is in.
Then 25th, then 20. Okay.
Logic, I have a first.